Okay, good morning all. Is everyone present?
Good morning, my lady.
Good morning, we are, my lady.
Good.
Good morning, my lady. We are
Thank
also
you.
here.
Good morning. And Mr. Keller, is Mr. Keller?
Yes, good morning, my lady. We also
Morning. Morning, Mr. Keller. Hope you have a better connection this morning. Mr. Keller? Mr. Klopper? Mr. Keller, are you still with us?
My lady, I believe that was Mr. Tsatsawane who was on the screen. I don't believe that Mr. Kiela was on screen yet.
Oh, okay. Oh, is it you, Mr. Tatsawana, who was saying good morning?
here. 10 minutes. Okay, sure. All right. Okay, sure. My lady, I just spoke to Mr. Keller now. He said to me that he had a puncture and he has just now been sorted out. He should be connecting in about 10 minutes.
Oh, all right. Well, then I think I might as well just hang up for now and then rejoin in 10 minutes.
Yes, my lady.
Okay, thank you.
Thank you.
morning again. Is Mr. Keller with us now? Paul, is Mr. Keller with us?
Morning, my lady. I do not see his account, but I do see the junior's account. I think Advocate Sabopa, I'm not sure which account are they connecting from.
Okay.
I can see the junior's account, but I cannot see Advocate Kedan's account.
So he's probably still trying to connect in.
Yes, my lady. Let me just try got hold of them.
Okay.
Thanks.
Good morning, my lady.
Good morning. Is that Mr. Keller?
No, it's Advocate Sebopa, the junior,
Okay.
Mr. Keller. Yeah, he is battling with connection. We agreed that perhaps maybe we'll meet in my chambers because so that he can be able to access the device. But we noted that we will undergo a load shedding between 10 and 12. So he suggested that he will have the proceedings heard from his house. So let me just try and find out what might be the challenge so far, because he was connecting the last time I communicated with him.
Okay. All right. Will you let us know, and will somebody let me know when he's ready so we can log back on? And Paul, will you send me a message?
Indeed, my lady. I'll let the court soonest I've managed to communicate with Advocate Gail and the matter.
Well, I'm sure Ms. Mashikisha will then let me know. Thank you.
Thank you very much, ma'am.
Thank you.
I'm in there.
Good morning again for the third time. Mr. Keller, I believe you are with us now.
Thank you, my lady. My lady, before I say anything, I must apologize to you and my colleagues on the platform, all of them. This has been a terrible morning for me. In fact, we took the leadership's advice yesterday because there was going to be a load shedding in Johannesburg. And then I resorted to my house, and also this morning the outage started. My attorney had to look for another venue. On my way to this venue, I experienced 2 tire punch on my car, and then I had to leave it there and take another option straight to the venue. I apologize sincerely, my lady.
It's definitely not your day. At the end of the day, you must have a drink with the president. It's his 70th birthday today to make up for the day.
Thank you, my lady. I hope that will make my day.
All right.
Thank
Good.
you.
As long as you're settled and ready to carry on.
I'm ready. I'm settled, my lady. Thank you so much.
Good. All right. You may proceed then.
Thank you. My lady, yesterday, in fact, we experienced, in fact, challenges in as far as our system, that is our connection is concerned. I was dealing, my lady, at that time with, in fact, the decisions that were taken, in fact, by the 16th and 17th respondent, in as far as this matter is concerned. And those decisions, my lady, are, in fact, if I may recap, in the event that the leadership did not capture me due to the challenges.
Yes, as I said to you, I got to the point where you said there was a budget of 50 million, and then I lost you completely.
Thank you, my lady. Let me just start there, my lady. It's number 3, my lady. That's decision number 3. The respondents, as I've referred to, 16 and 17, they took a decision that, look, we are going to allocate 50 million for this particular project. That is as a budget. That was prior to the appointment of the first or the fourth respondent in this particular instance. And then, my lady, then thereafter, another decision is that, my lady, of them appointing our client directly from the database as quantity surveyors, but in this particular matter. Subsequent to that, my lady, there were issues, my lady, in as far as the budget is concerned. It transpired, my lady, that the 50 million that was in fact decided by the 6th and 17th respondent, and in fact was not sufficient to cover but the cost of the entire project. Firstly, my lady, the challenges were the 50 million budget was not based on any, in fact, professional advice as to the actual cost of the project. To an extent that, my lady, when the professionals came in, my lady, they raised, my ladies.
Sorry. Are you saying that there was no basis for that amount? Was that just a thumbs up kind of figure that they proposed?
Yes, the 17 were proposing, in fact, they took a decision to say 50 million is here, 50 million is going to cover this. However, my lady, it transpired later on, my lady, that there were no scope and design. There were no scope and design to an extent that, my lady, same had to be done. And again, my lady, they took a decision to say, as professionals in this, professional service providers in this particular instance, in fact, deal with the designs, deal with the scope, and, my lady, when issues of budget were revisited, and, my lady, in the light of the design scope, the designs and the scope, again, my lady, the 6th and 17th respondent took another decision, which is, in fact, one of the decisions that I've mentioned, to increase the budget in order to accommodate, my lady, whatever was supposed to be done in order to take the project forward. That is decision number 4, my lady. And number 5, my lady, is the one of saying to them, make the design, do the scope. That's the decision, my lady, of the 16th and 17th respondents. And again, my lady.
Sorry, just repeat that the 5th decision. I didn't quite catch the first bit. You said there was a 5th decision?
The 5th decision, my lady, is that of saying, do the design and also do the scope. Because there wasn't any scope, there was no design at all.
And who was asked to do that?
My lady, the professional service provider, I will confine myself, my lady, to the fourth respondent in this regard.
Okay.
Yes. Those are the issues, my lady, that were at play. These are the decisions, my lady. The last decision, my lady, that I need to mention, which is very crucial in this matter, is, my lady, the decision which has been gazetted, which my lady says that, my lady, the fees, professional fees, in as far as, in fact, the fourth respondent is concerned, are going to be the professional fees as gazetted, the rates as gazetted, my lady. That's a decision, my lady, of the department. To simply say that, look, you are going to charge us in line with the gazetted rates. And, my lady, that particular decision, my lady, you can see it, my lady, without wasting your time. It finds its way to the service level agreement between the parties. My lady, the submission that I'm going to make in the light of all these decisions, my lady, that are highlighted, that is 6 of them. For the purposes of this, my lady, for the purposes of this particular review, my lady, they are not before you. In fact, in order to be scrutinized, in order to be reviewed and set aside, and there is no basis, let alone, in fact, that there is no prayer that deals with them to be reviewed and set aside, my lady. It goes without saying, my lady, in the absence of that, in the notice of motion, there is also no foundation. In fact, in the founding affidavit, that in fact supports such prayers in there, because there is no prayers, there is no basis for those. So, my lady, that is my submission. Had the respondent, the applicant, my lady, in these particular circumstances, my lady, if the applicant was so unhappy with these decisions, my lady, which are closely connected, my lady, to the deviation and the emergency procurement, if they were not happy about them, my lady, our expectation, my lady, as the fourth respondent, was that, my lady, they should have reviewed them. They should have asked the court through the notice of motion.
So if I understand you, you say that these decisions that you've just enumerated ought to be the ones that ought to have been set aside.
Ought to be the ones, my lady, not only, my lady. I won't say that, my lady. I won't confine them to simply say they ought to have dealt with this only. But I'm saying that, my lady, they ought, my lady, these decisions ought to have been, in fact, ought to have been a relief, in fact, a prayer in the notice of motion, and a foundation or a basis, my lady, in support of that particular prayer in the body of the founding affidavit, to simply say they must, in fact, come before the scrutiny of this honorable in the form of a review. But that has not happened. And secondly, my lady, they ought, my lady, in fact, as well, in as far as all these decisions that I've cited, my lady, dispatch the record, my lady, to the court and to the other respondents, my lady. At least, my lady, the court will have a benefit, my lady, of what was in the mind of the decision makers in these particular instances. Everything that is connected with these decisions, my lady, I'm going to seek refuge, my lady, as to what, in fact, the record ought to have been, my lady, it ought to have been in this particular instance, my lady. I will seek a refuge in the case law, my lady, to simply say, my lady, they ought to have dispatched the record. And the record, my lady, in line with the Helen Suzman Foundation versus Judicial Service Commission case. The citation, my lady, is Helen Suzman versus Judicial Service Commission 2018 ZACC 8. I will rely, my lady, heavily on paragraph, in fact, 13 of the judgment, paragraph 14, paragraph 15, and in particular, my lady, paragraph 18 of the judgment. Paragraph 18 of the judgment, my lady. Paragraph 18, my lady, it simply says, my lady, the words record of proceedings cannot be otherwise be construed, in my view, than a loose description of the documents, evidence, argument, and other information before the tribunal relating to the matter under the review at the time of the making of the decision in question. It may be a formal record, a dossier of what has happened before the tribunal. It may also be a disjoint indication of the material that was at the tribunal's disposal. In the latter case, it would, I venture to think, include every scrap of paper, throwing light, however indirectly, on what the proceedings were, both procedurally and evidentially. A record of proceedings is analogous to the record of proceedings in a court of law, which quite clearly does not include a record of the deliberations. I'll stop there, my lady. That's what exactly my lady should have been before her ladyship, and also before the respondents, in as far as, in fact, these particular decisions are concerned. However, my lady, that, my lady, the judgment, my lady, provides machinery on how, my lady, to dispatch such records. Such a machinery, my lady, it is being laid out in paragraph 13 and 14 of the same judgment, my lady. They simply say, my lady, if they wanted, my lady, to deal with these judgments, the Constitutional Court simply says the purpose of Rule 53 is to facilitate and regulate applications for review. The requirements in Rule 53 1B that the decision maker file the record of decision is primarily intended to operate in favor of an applicant in review proceedings. It helps to ensure that review proceedings are not lost in the dark. The record enables the applicant and the court to fully and properly assess the lawfulness of the decision-making process. It allows an applicant to interrogate the decision and, if necessary, to amend its notice of motion and supplement its grounds for review. Our courts have recognized that Rule 53 play a vital role in enabling a court to perform its constitutionally entranced review function. Without the record, a court cannot perform its constitutionally entranced review function, with the result that a litigant's rights in terms of Section 34 of the Constitution to have a justifiable dispute decided in a fair public hearing before a court with all the issues being ventilated will be infringed. My lady, of paramount importance, my lady, in the paragraph that I've just read, my lady, it emphasizes that, my lady, in the absence of a record, in this particular instance, we have no record. In fact, in as far as all these decisions are concerned, let alone the issues that I've mentioned with the notice of motion, the founding affidavit. In essence, my lady, my submission is that relationship, in line, my lady, with all the decided cases in this regard, in the absence, my lady, of those decisions are being set aside by a court of law. The case law, my lady, even the Kellen case law emphasizes that principle. They stand and then they remain binding, as long as, my lady, they have not been set aside. And, my lady, it goes further and says that, my lady, they are capable, my lady, of being implemented because they are binding. That is the essence, my lady, of my submission, my lady, when I'm trying to wrap up on the point of
and if I follow your argument, what is sought now to be set aside is it's not relevant, even if you set it aside, because the decisions from which those decisions flow have not been set aside. They're still valid.
That is the essence of my submission. Thank you so much, Maridi, because the service level agreement of the applicant, in fact, I want to put it this way, Maridi. These decisions gave birth, Maridi, to the service level agreement between the parties, in as far as their appointment is concerned, in as far as even the agreement between them and the 16th and the 17th respondent. It came as a result of these decisions. And one would, Malady, further take the matter in this particular fashion that the fortunate part of it, or the part of the fourth respondent, is that, Malady, those decisions were taken by the officials without the participation of the fourth respondent, because the authority vested with them. And, Malady, it goes without saying, Malady, that these services by the fourth respondent were rendered at the behest of the 16th and 17th respondent. Had they said to us, Malady, that look, we don't agree with you, and we're not happy with what we're expecting from you, we would not have been there, Malady. But because of these decisions, and because of these decisions, Malady, they appointed us. Malady, I'm going now to deal, Malady, I'm going to deal now, my lady, with the issue of review and set aside, my lady. Of a review and setting aside of the service level agreement involving the fourth respondent. My lady, I'm not going to repeat, my lady, in fact, the decisions that I've referred to earlier on, but my lady, in my submissions, in as far as the existence of those decisions, 6 of them, my lady, I will take it from that, but in fact, I will extend it from those submissions that dealt with those 6 decisions, in as far as setting aside this particular decision. My lady, in this particular instance, my lady, it is not the applicant's case, my lady, that first of all, my lady, 1 second, please, my lady. It is not their case, my lady. Again, my lady, that flowing from the service level agreement, flowing, my lady, from those particular decisions, they are now reviewing them, and flowing from that review of these 6 decisions, the contract as a result of coming from those decisions must be set aside. But they're not saying that, my lady. But what they are targeting, my lady, is simply the service level agreement, not the decisions that led to the conclusion of the service level agreement. And we submit that, my lady. If that is the case, my lady, the indication is that there was nothing wrong that was done in the form of taking those decisions. To an extent that they still exist, to an extent that they are still binding to them. But what we are not happy with is the fourth respondent's presence in this situation. That can never be, my lady. That can never be, my lady. Secondly, my lady, what also I need the fourth respondent need to make submissions of is that, my lady, they are not, my lady, even questioning the very purpose of going to tender. The decision is there, my lady. Before we get into the picture, there was a decision to say, let us go out on tender. And the secondary decision that I'm going to mention again is that under the circumstances, that is COVID-19, national lockdown, which subsequently took place, the department said that the tender process is not going to be a normal process. It will be done under urgent procurement processes. They're not questioning anything with regard to that money. And my lady, I'm not going to repeat, my lady, and waste your time by reiterating, my lady, the other decisions that I've already dealt with. But in essence, my lady, my submission is that they have not, my lady, even dealt with those decisions. Even, my lady, on their prayer to review and set aside. Putting aside the issue of a declaratory order. But now, my lady, even on this particular scope, under reviewing and setting aside, they have not dealt with those decisions. The very same submission that I've made in relation to the declaratory, particularly the absence of, in fact, of dispatching the records, the absence of, in fact, prayers in the notice of motion dealing with, in fact, these decisions under review and setting aside of this decision, and also the founding affidavit, those submissions will also be applicable in as far as they attempt to review and set them aside. My lady, another issue, my lady.
Just a minute. I just want you to complete the thought, because you talk about the decision to follow not the normal tender process, but the urgent process, and you say that the SIU has not dealt with those decisions. In the absence of the record of those decisions, they're not entitled. Logically, you say they're not entitled to the relief they're now seeking.
Not at all, my lady. Not at all. Not at all, my lady. And my lady, if I can sum it up, even the very same officials, my lady, that took these decisions, which my lady I've already made submissions on, There is no, my lady, as Mr. Tatawana, if I had to write it, their authority has never been questioned under the procurement processes to simply say you are dealing with unauthorized persons or officials. Not at all, my lady. And my lady, it goes without saying, my lady, that the decision still stands. The authority of the people that the fourth respondent was dealing with is not even being questioned by the applicant. They were officials that were meant to deal with the procurement processes. From the head of the department up to the last person that was involved in this matter.
Mm-hmm.
I would like to align myself with my learned colleague, Mr. Holtz SC.
Sorry, Mr.
Mr. Holtz, if I'm pronouncing his surname.
Mr. Holtz. Mm.
Yes. If I listen to him carefully, he dealt with the differences between the normal procurement process and the urgent procurement processes. He dealt with the issues of competitive bidding under normal procurement circumstances and quotations and negotiations under urgent procurement processes. I'm not going to waste the leadership's time. I align myself with what he has submitted on in these particular instances.
Mm-hmm.
Already, it appears that, my lady, if I've captured, in fact, the case of the applicants properly, that, my lady, the applicant bemoans or complains about, in fact, issues of quotations and negotiations. I'm baffled, my lady. That is my humble submission. I'm baffled, my lady.
Sorry, you're becoming muffled again, Mr. Keller. I didn't hear that. You said, what about the quotations?
The quotations and negotiations, my lady, under the urgent procurement processes. My lady, it goes without saying. Once there is a service level agreement, my lady, once there is an agreement in law, the agreement in law, my lady, there is a very, in fact, famous, in fact, term that the agreement comes into place as a result of the meeting of the minds of those involved. And the meeting of the minds, my lady, usually, my lady, is a situation whereby there are discussions and negotiations. And then the parties agree on the terms and the conditions, and then thereafter they sign a document. If one of them is not happy, he's not bound to sign the agreement. If they are happy, there is a meeting of the minds, and then of course there will be an agreement. And then usually it must be preceded by negotiations or discussions in order for it to be an agreement between the two parties. I submit that, my lady, this particular process, in as far as the fourth respondent, was effectively complied with. My lady, I submit that, my lady, in the light of the submissions that I've made, in as far as the reviewing and setting aside of the service level agreement, my lady.
No, of the fourth respondent.
Of the fourth respondent. My lady, no case has been made out, my lady, by the applicant. My lady, we are having a situation whereby, my lady, instead, my lady, of dealing with a layer that continues to lay the eggs, why to destroy the eggs once the layer is busy producing the eggs. That is exactly the situation that we are dealing with. The decisions are there, they are binding, they are being implemented. But, my lady, the applicant simply wants to get rid of the fourth respondent. My lady, I'll jump into It is an issue, my lady, that we spend a lot of time in dealing with in the form of preparations, as the applicant indicated earlier on that this application is partly on behalf of the SIU and partly on behalf of the 16th and 17th respondent. My lady, we took time in dealing with this issue as the fourth respondent, trying to get an understanding. How can we represent a person who is, in fact, standing on the other side of the fence? We took an issue, my lady. We took time, apologies, my lady, to ascertain which position, in fact, the applicant is in as far as this application is concerned. Particularly, my lady, in the light of the engineering case law, which simply says that it's possible for departments, for one organ of state, to institute review proceedings against another organ of state. And in this instance, it has been submitted to you that in this case, that is not the case. They are partly on behalf of the 16th and 17th and partly on behalf of the SIU. My lady, I'm going to take you, my lady. And Mr. Klopper also dealt with this, my lady. I remember very well, he said, the applicant cannot have this bread buttered on both sides. My lady, I'd like to take you, my lady, to the founding affidavit of the applicant. It's page 078, 10 or -10.
Just give me one moment. Give me one moment. Sorry, what is the reference again? Bundle number 078.
078-10.
10.
10 to 11.
Sorry, you're breaking up again. It's sorry, 078 dash
10 10,
Mm-hmm.
10, my lady.
Yes.
Paragraph number 2.
Mm-hmm.
I'm duly authorized to institute this application on behalf of the SIU, as appears from the relevant delegation of authority, which is attached marked FA1. If your leadership goes to FA1 without wasting your time again, FA1 can be found on 08-107, the same bundle. My lady, my submission in this regard, it becomes more apparent, my lady, from this founding affidavit, of which the applicant is supposed to make out his case. That, my lady, what was said earlier on, when read with this paragraph, it says nothing about the application being launched also on behalf of the 16th and 17th respondents. When you look at FA1 as well, it's very silent about the applicant appearing on behalf of 16th and 17th respondents. If the leadership is with me in this regard, the leadership, I'm going to ask the leadership to dismiss or to refuse, in fact, this application, which purports to be launched on behalf of the 16th and 17th respondents. And since we have spent time in this matter, my lady, in as far, my lady, as determining the position of the respondent, in as far as this application is concerned, in as far, my lady, as aligning what has been told, what has been, in fact, what has been submitted before this court. But when we go to the founding affidavit, my lady, it does not support such a submission. We are asking the court, my lady, to refuse any attempt, my lady, for the applicant to partly launch this application on behalf of the 6th and 7th respondent with cause. And my lady, in that particular regard, let us submit further that, my lady, it becomes more clearer now that, my lady, this is an application by one organ of state against the other, as outlined in the engineering case. Leadership, the reason why, my lady, I'm dealing with the issue of requesting the court, my lady, to refuse such an application on behalf of those respondents. And the reason why, my lady, I'm dealing with the courts in that regard, my lady. Court should show its displeasure, my lady, particularly in instances whereby, my lady, a case is pleaded on the papers, and then my lady, all of a sudden, there is a departure from what is pleaded from the pleadings in order to make a court to arrive at a conclusion, which is premised on issues that are not covered by pleadings. My lady, I have a judgment in this regard. And the judgment, my lady, is Minister of Safety and Security. I'm going to give a full citation now, my lady.
Yeah.
1 second, please, my lady. It's an SCA judgment, my lady. I'm going to give a full citation. It's a Minister of Safety and Security versus Labet in bracket 668 /2008 closing bracket in brackets 2009 Zaska 1.
Sorry, no, I'm not following you. It's bracket 668 and then?
And then brackets again 2009 Zaska 163.
All right.
18 November 2009. And the paragraph, my lady, that I want to draw to your ladyship's attention. 11. The purpose of the pleadings is to define the issues for the other party and the court. A party has a duty to allege in the pleadings the material facts upon which it relies. It is impermissible for the plaintiff to plead a particular case and seek to establish a different case at the trial. It is equally not permissible for the trial court to have recourse to issues falling outside the pleadings when deciding a case. That's exactly what I was saying, Malik. In this instance, a case that in fact an attempt has been made to deal with in this paper, one that was brought to the attention of the court and other respondents, is that of the applicant launching this application on its behalf as an organ of state.
I just want to pause there because, you know, obviously the Act is very specific when it says that the SIU may institute civil proceedings either in its own name or on behalf of the organ of state. Would your argument have been different if the 15th, 16th, and 17th respondents were co-applicants?
In that particular case, my lady, my answer, in fact, in an attempt to deal with the leadership's question is that, first of all, my lady, it would have been brought to our attention and would have been given an opportunity to deal with it in that particular regard. Secondly, my lady, the fourth respondent, my lady, cannot decide as to who is the applicant and who's not the applicant.
No, what I'm saying is let's assume that SIU said SIU first applicant, Department of Health second applicant, Department of Infrastructure Development third applicant, and Treasury's fourth applicant. Would that have made a difference to your argument now? Because you're saying you can't act on behalf of somebody who's on the other side of the fence, namely being a respondent. So I just want to hear if your argument would have been different had the 15th, 16th, and 17th respondents been cited as co-applicants.
My argument would have been different, my lady, because I would have been in a position, first of all, at least to know that these are the applicants. Secondly, the body of the founding affidavit would have laid a basis why, in fact, they are the applicants and on what basis are they launching the application. To an extent that, my lady, I was going to be given an opportunity later on in my answering affidavit to deal with those issues, my lady. if I have any issues with regard to that. But in this instance, that was never done, my lady. Instead, I find them, in fact, in the pecking order of the respondents. One second, please, my lady. My lady, I've made submission on that particular issue. My lady, I'm going to deal now with the last issue, the dispute of facts. If the leadership, our primary submission.
Last issue, I can't hear you very well. Which last issue?
The existence of the dispute of facts.
Oh.
Thank you. The leadership, I understand, in fact, most of the respondents, which I align myself with, are saying that, my lady, this application should be dismissed. We are also saying that, my lady, no case has been made out for the granting of the orders as prayed for in the notice of motion. And if the leadership is with us, that will be the end of this matter. Surely, my lady, there won't be any need, my lady, to deal with the issues of dispute of facts, to deal with any other issues such as overcharging and so forth. But, my lady, as a fallback position on the part of the fourth respondent, that is, if your leadership is not with us in as family as our primary, in fact, the submission of dismissal is concerned, we are simply saying, my lady, the issue of the dispute of fact has already been anticipated by them in their own papers. To an extent that, my lady, in their founding affidavit, they have indicated that that is a matter for another day. And the platform that is suggested in the founding affidavit are action proceedings. And in that regard, my lady, we are also of the same view. However, the applicant, my lady, turned around and simply said that issue should be entertained in motion proceedings as well. My lady, I'm not going to waste your time because I've dealt extensively in my heads of argument.
Your heads, yes, you have.
Dealt with, and also in the board of the founding affidavit, I've dealt extensively with the existence of the dispute of fact. However, my lady, there are pertinent issues. It's not only the content that is, in fact, disputed in this regard, even the status of the report itself, my lady. And once that happens, my lady, it calls for the drafter of the report to come and explain. For an example, my lady, without wasting your time, the Code of Ethics, in as far as the quantity surveying profession is concerned, there are two clauses there, my lady. It's clause number 311. Rules of misconduct.
Sorry, just a minute. 2.11.
3.11.
Okay. Yes.
That a quantity surveyor may not knowingly attempt to supplant another registered professional quantity surveyor in a particular appointment after the client has employed other registered professional quantity surveyor. 3.14 may not review for a particular client the quantity surveying work of another registered professional quantity surveyor. And then the exceptions are there, Maliki. Yeah.
Mr. Clare, that code of conduct is attached to your answering affidavit, is it not?
It's not, Maliki. I must mention that, but it's been mentioned in the report itself, in the report of the quantity surveyor. It's been mentioned.
Okay.
Thank you. So, my lady, there are three exceptions, my lady. The exceptions are 3.14.1, 3.14.2, and 3.14.3. Without going to the exceptions, my lady, the report itself, my lady, it needs to be explained by the person who drafted it. It's termed Financial and Technical Evaluation Report of the AngloGold Ashanti Hospital COVID-19 Facility, Section 1, Quantity Surveyors Report.
You're referring to the Mutara report now.
That is correct. It needs to be explained by Mutara as to whether this is a review in terms of clause 3.14 and as to whether by going, in fact, into the scope of the work that was allocated to a fellow quality surveyor, it should not act in contrary with 311. Those answers, my lady, can only be achieved through, in fact, the questioning of the person who compiled this particular report. And the question can only be posed to him or to her. So, my lady, production of a mere report with those handling questions, my lady, is not going to resolve these issues. And who knows, my lady, she might say that, look, I'm not reviewing my fellow quality surveyors' work. That was not the essence of the report. And I've not, in fact, I've not acted in contravention of 311 because my scope of work was 1, 2, 3, 4. Those can never be answered by the applicant, but simply by Mutara himself or herself. If the leadership at least reaches that particular stage, this matter reaches that particular stage, your leadership is requested, in fact, to say that this matter should be referred to oral evidence so that, in fact, these issues can be resolved. Pertinent to that, my lady, or connected to that, my lady, there is a decision, my lady, which both the department, the 16 and 17 respondents, it was a decision first, and then it finds its way into the service level agreement between the four, to simply say your fee rates will be the ones that are gazetted. And then, my lady, the draft of the report will have to be taken through his own, in fact, analysis in as far as the gazetted rates are concerned. Because, my lady, first of all, their source, which is a decision of the department, still stands. So, my lady, in a nutshell, my lady, in conclusion, before I take instruction quickly from my attorney, we are saying, my lady, this application, my lady, it's a botched surgery.
Sorry, I didn't hear that. It's a what?
It's a botched surgery, my lady. The leadership would notice even from the submissions of the applicant. Correct me if I'm wrong, the leadership. He was talking about competitive and open and transparent bidding process. You can see, my lady, that despite not reviewing the very same decisions that I've referred to earlier on, they are expressing unhappiness with them to an extent that, my lady, they infuse whatever was supposed to have happened in a normal procurement process into an urgent procurement process. Their unhappiness, my lady, is glaring. However, the review, my lady, is not about the happiness of the applicant. It's about a case that has to be made out in the papers. And, my lady, an urgent procurement process, I submit, should not be looked at, my lady, through the processes of a normal procurement process. It's a separate process. It's totally distinct from a normal procurement process. And, my lady, I repeat this is very crucial submission, my lady, when I'm finalizing the submissions. At no stage, my lady, are they questioning the very authority of the very officials throughout this action procurement in dealing with these processes, not at all. Lady, can I just take 1 second to get an indication?
Yes, certainly.
Thank you. Thank you, my lady. My lady, in as far as the issue of cost is concerned, my lady, the fourth respondent is asking for the dismissal of this application and is asking this honorable court, my lady, to grant costs in favor of the respondent. My lady, we have been made to run a marathon. We have been made, my lady, to deal with a matter that ought not to have found its way into the review court. In the light of what I've submitted, my lady. My lady, the applicants, the respondents should not be out of pocket as a result, my lady, of the conduct of the applicant. My lady, if I may, there is a case, my lady, in Zika case law. I don't have it with me. But the principle is that, my lady, the matter must mainly turn on the pleadings. It also says that, my lady, before you draft the pleadings, at least you must know the law. It goes again, my lady, and says the pleadings are for the court and not the court for the pleadings. So, my lady, with those submissions, my lady, we submit that, my lady. A punitive cost order, my lady, if the relationship is with us against the applicant, should be ordered to frown upon a conduct whereby, my lady, cases of this particular nature finding its way and occupying a space which could have been occupied by cases that have merits. So those will be our submissions.
Thank you, Mr. Keller, and well done. You've followed in Mr. Ellis's and Mr. Hodis's footsteps in doing it in an hour.
Thank you, my lady.
I think you've beaten their record just a little.
Thank you, my lady. I must also, my lady, again apologize for the delays earlier on.
It's understandable. Thank you so much. Mr. Arendse, are you ready to reply?
Yes, my lady, thank you. We will reply in the sequence.
Sorry, just before you do that, Ms. Mashatisho indicated to me this morning, or she indicated that there was a query from the legal representatives of the first respondent whether they should be here to argue costs. I can't prevent them if they want to. I just am inquiring if somebody is here. Ms. Mashatisho?
Judge? Yes, Judge. Judge, the attorney just said to me, they sent an email saying that they would argue after the tea break. I guess they assumed that we'll take a tea break before Mr. Arendse comes in. Let me just try to get hold of the attorney before Mr. Arendse.
Yes, because I just recalled now that you said they wanted to argue the question of costs. Maybe if they're not able to now, Mr. Arendse, and perhaps the other respondents can suggest a way forward as far as they are concerned.
Well, I suppose they could address you once I've completed my reply.
Yes, and well, I don't.
If there's anything for me to reply to in turn, if you could afford me that opportunity.
All right. Okay, well, let's carry on for now, and then we can afford them an opportunity later if they wish to argue.
Yeah. So, my lady, as I said at the outset, we will follow the same sequence in which the respondents argued, and deal with Mr. Kela last, if necessary. So first up was the third respondent, my lady. The first point that we want to make is that in relation to the legality relief, the third respondent say in their answer, and that's at case lines 054352.
Just a minute. So this is in respect of the third respondent.
This is now the third respondent, and you'll recall that Mr. van der Vyver
yes.
had addressed you. I think you, in fact, raised the issue of whether they were still, because we had contended that they are not opposing the relief sought in prayers 1 to 4.
Yes.
So it's in that context that I make this submission.
Okay, and this is in relation to the legality issue, and you're giving me a reference, and I didn't quite follow you. Their
reference is at 054-352 at paragraph 3. Paragraph 3. They say they are unable to dispute the relief sought in prayers 1 to 4 of our amended notice of motion. However, in the very next paragraph 4, they say they, however, oppose the just and equitable relief. So our submission in that regard is that the third respondent doesn't oppose or meaningfully oppose the relief sought in prayers 1 to 4, for the simple reason that they cannot dispute what we have said in that regard. The next issue addressed by Mr. van der Vyver was that the third respondent denies that it validated any rates or prices or the like, because they placed that obligation on the fourth respondent. Clearly, we say, my lady, in an attempt to minimize their role in the project. But we submit, my lady, that it's clear from the record, and I'll give you the references, that it was the third respondent that was the party the contractors approached for site access, documentation, and the reference, my lady, is actually to the 11th respondent's answer. It's at 091-119 2-120. And similarly, my lady, from the 11th respondent's answer at 091-174, that it was the third respondent that gave instructions on the scope of works. My lady, we also, in response to that contention by Mr. van der Vyver, we also refer you to the third respondent's service level agreement, or what purports to be a service level agreement, which you will find at 028-628. Where at clause 6.1 of that document, the third respondent is appointed as the construction project manager, and with duties and responsibilities commensurate with that appointment, and which is also set out in that annexure. But of course, we know from just looking at it, it's not even completed. And at 6.2.1, clause 6.2.1, my lady, the same reference page 028-628. It was the third respondent which was required to identify all the consultants for the specific disciplines required to successfully plan and execute the project.
Sorry, I was just interrupted by the lights coming back on. It was the third respondent who did what?
It was the third respondent which was required, my lady, to identify all the consultants for the specific disciplines required to successfully plan and execute the project as per that service level agreement.
Thank you.
But my lady, if we look more closely at the agreement, and I want to refer you to Annexure B of that agreement, which is at 028-646. Which is supposed to be a work schedule, my lady. You'll see from that annexure that it is blank. Now, just two things, my lady. It's our duty to point this out to you. That schedule and that page is very poor on case lines, my lady, and is hardly legible. But the version that we've seen is blank, and I think in response to a 3512, we may have offered to, we either sent them a better copy or we may have offered for them to have a look at it. But the point is, my lady, it wasn't contested, or it isn't contested by the third respondent. There's no other version. The next document, my lady, which is supposed to be the program and cash flow information document, it's Annexure C on the very next page at 028-647. Is also blank. And one just sees the word sample across it, my lady. So we submit that there are no duties and responsibilities set out, no work schedule, no program, or cash flow information. And that, my lady, applies to all the other respondents. Their contracts are similarly blank, incomplete, and thus, as a matter of law, my lady, the trade submission is that no contracts, let alone valid contracts, were concluded. There's no question of any minds meeting, unless it was in some vacuum, my lady. So our submission, my lady, in that regard is that the appointments could never have been made or rationally made because there was no transparency. And there's no indication that there was any fairness as far as the appointments is concerned. So it was just open to abuse. And my lady, just while I'm there, if I may just respond to a comment made by my colleague, Mr. Ellis, otherwise a good friend of mine, that I had made some comment recklessly about 50 million to 500 million. I repeat it, my lady, because it's on the record. The record, the 50 million mentioned for a 300-bed hospital, that was on the 24th of March 2020 in an internal GDID communication requesting for the appointment of PSPs and contractors on an emergency basis. It's at 78-61 and 078-73 to 74. And then we see how this figure, like Pinocchio's nose, my lady, grew to 515,798,277. I almost sound like a former president of ours, my lady. I can't even read this.
Oh, I missed that. You froze up for a few seconds. I heard that how this figure grew like Pinocchio's nose, and that's all I heard.
Yeah, just the figure of 500. It grew to 515,798. Yeah, 798,277. That is the amount that has been paid out as at December 2021. And that, my lady, is at 078-93 para 171. Now, my lady, that is crucially important in the context of discussing and our case based on the rationality of this whole project. Is we have a project, my lady, where first we will deal again with the alleged validity of the appointments, but also where there's lots of documents, blank, incomplete. Figures are filled in by contractors as they go along, and they are paid even before contracts are signed, ultimately costing the taxpayer a huge amount of money. For which someone must be held accountable. And your ladyship will know from the act that establishes the SIU and this tribunal, and read with the regulations and the rules, and of course the President's proclamation appointing the SIU to investigate these kinds of matters, that it's the SIU's duty to bring this to the attention, firstly to report to the President once the investigation is complete, but then if there's any irregularities, unlawfulness, unconstitutional conduct apparent from the report, to bring it to this tribunal. And that's what this tribunal has done. It's not a case, my lady, of bringing it on behalf of the 16th or the 17th respondent. It's a statutory obligation on the part of the SIU to bring it to this tribunal. And there's an obligation on the individual respondents to account for what they've done. And where we are, my lady, in the case is that even if the contracts / appointments are set aside by this tribunal, it's still the case that most of the respondents, if not all of them who worked on the project, will retain the bulk of the monies paid to them. The relief that we seek in the second part of the case is really to ensure, and this is a rule that's been established by the Constitutional Court in the all pay case, is that they shouldn't profit from an invalid contract. But for work actually done, actually earned in accordance with rates that's accepted in the industry, etc., they will retain those monies, my lady. Just lastly on that point, on the amount that grew from 50 to 500 million, is that the sad fact, as we speak, my lady, is that this facility, this hospital, is a complete white elephant that has cost the taxpayer in excess of 500 million rand. For which it was identified by the GDID and health, was never realized, was never achieved. to treat COVID-19 patients. I think that state of affairs should concern all of us who are taxpayers, including my colleagues who appear for the various respondents. Now, my lady, on the panel of PSPs, there were some 169 of them, my lady. And that you'll find at case lines 028590 to 028603. So in relation to the appointment of the PSPs in this matter, is that 3 to 7, my lady, respondents 3 to 7. All we have is Mr. Tabani's statement, which is in an email attached to the papers at 028588. That the PSPs were appointed on a manual rotation basis. Now, my lady, if we accept, as we do for the purposes of argument, that that's a primary fact which is not disputed, and which our colleagues for these PSPs in this case rely on, that's a primary fact, then we ask what may we infer from that fact? My lady, we ask rhetorically, why were only these 5 PSPs in this case, why were they approached and phoned by Mr. Tabani? On what basis did he decide to identify only these 5? Now, one might say, or your ladyship might even ask, and my colleagues will say, but why didn't you cite Mr. Tabani as a party? Why didn't you ask him? The answer is, my lady, he was asked, and the only response from him was the email that is part of the record. And otherwise, we also know that, and the list is on the record, my lady. Mr. Tabani is also one of the officials in this case that is facing disciplinary action. Another rhetorical question is, why were none of the other 164 PSPs not similarly contacted by Mr. Tabani? If we had an answer to that, my lady, perhaps an argument could have been made that there was some equality of treatment, fairness in treatment, which is consistent with Section 217 of the Constitution. Now, Section 217 and all our other procurement laws are there for members of the public in relation to goods and services procured by the state with taxpayers' money. And all of these, certainly not all of us, because a lot of us, well, we're talking about a group of PSPs who are presumably similarly placed. They do this kind of work. They're all on a panel. But they are entitled, my lady, to bid and to compete for a contract which turned out to be a massive contract. They were denied that opportunity. It's unlawful. It's unconstitutional. It's unfair that they were denied the opportunity to participate on this project. So simply put, my lady, it just doesn't make sense that only 4 or 5, sorry, of these PSPs, respondents 3 to 7, are appointed from a panel of 169 without any explanation. One can only conclude, and we submit, my lady, that that is totally irrational. The taxpayer, members of the public, deserve better. My lady, may I at this point ask for us to take the tea adjournment?
Yes, for how long? Till 11:15?
Yeah, just the usual 10-15 minutes, my lady.
All right. Well, it's 11:15 now, so what?
11:45 until 11, my lady, with your leave and with my other.
Yeah. All right. Let's take a 15. Is everybody else happy with the 15-minute break?
We're happy with that, my lady.
Okay, good. I'm taking that that was you, Mr. Tatswana.
Yes, that was me, my lady.
Okay, and all the others, I take it you have no problem with that?
Yes, my lady.
My lady.
Good, thank you. We'll take the tea adjournment now and resume at 11. Thank you.
You're muted, Judge.
Mr. Aaron, so there you are. You're ready. Before we proceed, I just want to ask, without putting any pressure on you, about how long more do you think you're going to be?
My lady, I will definitely finish today. It always depends also on the level of interaction, but I would think that in respect of some of the respondents, I'll be maybe 20, 30 minutes, and others outer limit of an hour. So we should comfortably be finished this afternoon, my lady.
Because I was asked about my availability for a meeting with counsel in one of my High Court matters for today. And I said, I really don't know. I'll just check with you, how long you envisage you're going to be. And I didn't want to make any arrangements until I heard from you. But let's see how we go. And, if it's still just counsel's availability, as you well know, is always a problem for meetings and so on. But I said I would just canvass that with you. But, and as I said, I don't want to put pressure on you, carry on. But if we are able to finish at a reasonable hour, then I might still be able to put that meeting together.
And if necessary, my lady, and also if my other colleagues are not opposed to it, we can have a shortened lunch or
well, yes, I was envisaging that if we either a shortened lunch or maybe just sit through until you're done. Yeah. But let's see how we go. Just that I need
any
to.
problem if the court sits through lunch, or perhaps just take a short comfort break during lunch.
Yes, I was thinking that as well. That we could do that, maybe a 10-minute comfort break, and then we just carry on.
I'm also in agreement with that proposal, my lady. Thank you.
Thank you. Thank you, Mr. Keller.
Thank you.
All right, so shall we continue?
My lady, we accept the proposal.
Sorry, is that you, Ms. Govender?
Yes, my lady, my apologies for the interjection. We were just indicating that we are also in agreement with the proposal that we sit through lunch.
Thank you. What we need to bear in mind that the first respondents' representatives may want to also argue on costs, so I have to allow them some time on that as well.
Yes.
All right.
We also put the arrangement, my lady, but we show Mr. Arendse will finish by lunchtime. But
yes, I know. His argument is going to be quite crisp in many respects.
Yes.
I share your optimism, Mr. Tatsawana. All right, let's carry on then, Mr. Arendse.
Thank you, my lady. My lady, still with the third respondent, shouldn't take much longer. The last point I made was the rationality point, my lady, the appointment of the 5 PSP from a panel of 169. So just to move on from that point, the next submission we make is that there was also no price negotiation with these PSPs. Their contract percentage, my lady, their contract percentage cap of 19% was only agreed at the end of July 2020. And that was well after the project was supposed to have been completed in May 2020. The reference for that submission, my lady, is 028 703 to 706. 02, yeah. So again, my lady, we see an absence of cost effectiveness, which is what procurement, which is what 217 of the Constitution demands, and which is what our procurement laws demand. And we submit that too is a ground of irrationality. The third respondent, as well as the other 4 PSPs, all had the same cap applied. And according to our expert, Ms. Mutara, this fee percentage cap is high. And she says that in her report is 087-9. Because the usual percentage cap is between.
Mr. Arendse, you've frozen up again. I didn't hear that. You said the usual cap is what?
The usual cap is between 10 and 12%.
Mm-hmm.
And the reference to Ms. Mutara's report is 087-9.
Yes, I've got that.
So, my lady, as a matter of fact, of evidence, and applying any legal principle, Plascon evidence, none of the PSPs filed any expert reports, my lady, to refute that submission. So again, my lady, the point is, had we had a competitive bid and a fair process, we will never know which of the PSPs amongst the rest of the 164 PSPs on the panel may have offered a better, more competitive price to the state to save on the refurbishment of the hospital. So by now we know in June, the department, both of them, have dug themselves into a hole. These PSPs have been appointed with what we have said at the outset, a blank check. The work has commenced, was supposed to finish in May, and at the late stage, this percentage cap is agreed at 19%. Doesn't make it a valid agreement, my lady. It may be a valid agreement because there's a consensus, as we understand in the law of contract, as a basic proposition, but it's certainly as a matter of constitutional law, it's not a rational approach to this matter. Effectively, the 15th and 16th.
Mr. Arendse, you've frozen up again.
I said effectively, my lady, the 15th and 16th respondent were held over a barrel and had no choice but to agree the 19% cap in respect of all the PSPs. Then just moving to the last point on Mr. van der Vyver's address on behalf of the third. He took your ladyship to our expert report at 087-180. where the mechanical engineer considered the HVAC, wet and medical gas assessment, and as a point of criticism, my lady, he referred to the pricing for a, I'm not sure the pronouncement is right, Cinto Care Hospital Project, CINTOCARE, which was tendered in 2018. And the point of his criticism was that that could not be used to validate hospital rates in 2020. But our response to that, my lady, is that this is a misleading statement with respect. But the very same expert, our expert, on the very same page, my lady, also compared it to the 300-bed Jubilee Hospital project in Gauteng, which was priced in June 2020. And other HVAC projects. And she also added that the costs were not made available, or estimates were not made available to her from some of the contractors on these selected items. So the only point we make in this regard is that the fact that there was reference to a 2018 rate or tender doesn't invalidate Ms. Mutara's report, or it doesn't make a report unreliable. So, my lady, that concludes a reply in respect of the
third respondent.
Yes, I think the next respondent was the 7th.
I'll tell you now.
The eloquent Mr. Satawani.
Yes, I think it was the 7th.
Yes,
followed by the 10th and the 13th. Yes, you're quite right.
Now, my lady, you will recall that we had opposed and still oppose the introduction, the late introduction by the 7th respondent on the 12th of October, after pleadings were closed, after our heads of argument were filed, these points were introduced. And we still maintain out of hand. But for just to make sure that we are not directed at the last minute to deal with these points, we nevertheless, as Mr. Tsatsawane pointed out, we did deal with them in our answer to the application. And so firstly, my lady, the reason why, the fundamental reason why they say they filed this so late was because of a new legal team being appointed. And my lady, we submit that that has never been a valid excuse or reason why a new matter, a new point ought to be admitted into argument by the court. Because these points are not covered in the answering affidavit. The first one, which was filed, I think, on the 2nd of August.
In any event, that condemnation for that late filing was not opposed, so that was granted. We're dealing with
Yeah, no, that we of course we granted one of the second.
So it was just the application to file the supplementary affidavit.
Yes.
Or rather the application to file that, and that was what we were dealing with. Mm-hmm.
Yeah. Now, in our answer to the introduction of the supplementary affidavit, we took the court to the initial answer we took, Your Ladyship, to the 7th respondent's response to the founding affidavit.
Your answering affidavit to the 7th respondent's application.
Yes, we referred to their original response to the founding affidavit, which was merely to note that the review was being pursued under the principle of legality. And that's at 101-51.
Just a minute. And this is now the 7th respondent's answer you're referring to.
No, our answer, my lady, to the supplementary affidavit of the 7th.
Okay. And this is
101-51 at paragraph 65.
Yes.
The point is that the 7th respondent had not placed in issue the SIU pursuing this review on the principle of legality. So it has now belatedly, my lady, done a complete about turn. So for that reason, my lady, our opposition stands and we submit it shouldn't be allowed. But we deal with it.
Mm-hmm.
So in response to the jurisdiction points that this tribunal is not a court and cannot determine reviews or grant relief under section 172 of the Constitution. And because, my lady, we raised this and mentioned this in our answer to their application, Mr. Satawani accepts that this tribunal has already dealt with the arguments and have found against him. So for him to succeed, my lady, he would have to show that previous decisions of this tribunal and the SCA are clearly wrong. And he's got to do so for the following reasons, my lady. Firstly, we refer your ladyship to the Act at section 8, brackets 2.
Just a minute. Section 8.2 of the Act, yes?
8.2 of the Act, which reads that a special tribunal shall have jurisdiction to adjudicate upon any civil dispute brought before it by a special investigating unit or interested party as defined by the regulations emanating from the investigation by such special investigating unit, including the power to issue suspension orders, interlocutory orders, interdicts, or make any order it deems appropriate, give any ruling or decision, or make any order that it deems appropriate as to cost. We submit that this section properly construed, must be interpreted to be inclusive and not exclusive. We submit it's evident, and we are supported by case law, that judicial review is certainly a civil dispute within the meaning of those words. And on a plain reading, in adjudicating civil disputes, the tribunal may issue interdicts, interlocutory orders, declaratory orders, etc., to give effect to its decisions. We also refer your ladyship to Regulation 5.2 of the SIU regulations. And that is, which includes civil proceedings for any relief for the recovery of any damages or losses which may be suffered by a state institution. And then it lists certain types of specific proceedings that may be brought. So we submit, my lady, the only limitation on the types of civil proceedings that can be brought before the tribunal are that the dispute must be a civil one, civil dispute, and crucially must emanate from an SIU investigation. And that the proceedings may only be brought by the SIU or an interested party. And an interested party is defined as a party with a direct and substantial interest in any judgment the tribunal may make. And we submit, my lady, that in respect of the money aspect of this matter, the disgorgement of profits aspect of the case, that arises directly from an investigation conducted by the SIU seeking to declare any contracts entered into with the respondents unlawful and or unconstitutional, and that falls squarely within the type of relief contemplated by the Act and by the regulations. Now, my lady, we submit that Mr. Satswani, as eloquent as he may have been, has got a very hard road to hoe, because his submissions are not supported by the authorities, my lady. The first matter we want to refer to is the SIU versus Nadasen, Nadasen, brackets 2002, to all SA 170, brackets capital letter A, at paragraph 10. And I quote, reverting to the scheme of the Act, a unit, that's a SIU, must investigate the matter referred to it, collect relevant evidence, and may then institute proceedings in the tribunal against the parties concerned for the recovery of what is due to the particular state institution, brackets, sections 41A and B, 5.5 and 5.7. And this is the part that we underline, my lady. The tribunal consists of a judge, and has in general terms the powers of a High Court in relation to matters falling within the terms of reference. That's relying on sections 7, 8, and 9. Appeals lie against a judgment of a tribunal to the full court or to this court. So this is very different, my lady, to the Water Court or to the CCMA under the Labour Relations Act. From the CCMA, you go to the Labour Court. Where a single judge would hear any review of an arbitration award, for example. The next case, my lady, we want to refer to is the well-known case of Ledla, SIU versus Ledla, LEDLA, Structural Development Pty Limited. The reference is brackets GP07/2020, close brackets, 10 December 2020. And it's a decision of Judge Motley, as he then was. He's now in the Supreme Court of Appeal, isn't he?
Yes.
Where he found, well, of course, it doesn't make this decision right, but...
yes, well, in any event, we're still waiting to hear the Constitutional Court's view.
Yes, my lady, it is pending. Where Judge Motley found that the tribunal performs the functions of a civil court, that's paragraph 46 of that judgment, and it has the power to adjudicate reviews as there are civil proceedings, that's paragraph 50. Then a judgment, my lady, of the Judge President of this tribunal, the matter of SIU versus Caledon River Properties, Pty Limited. It's brackets, square brackets, 2021, close square brackets, ZAST 4, ordinary brackets, 26 February 2021, judgment of Judge President Madiba, where in fact, my lady, the respondent raised precisely the same issues raised by Mr. Satwani, the same points of law, and they were dismissed with costs. So Mr. Satwani is quite wrong to have maintained or to have submitted to your ladyship that these questions have never been answered by the tribunal. This is at paragraph 69 of the judgment.
Just a minute, please. Paragraph 69, yes. 69
of the judgment, my lady, reads as follows. This special tribunal concludes that, colon 69.1, the respondent's point of law is not supported by the legislative framework and judicial authorities dealt with above. 69.2, the special tribunal is a court with status similar to the...
You've frozen up again, Mr. Arnsel.
Sorry, my lady. Did you hear me quote from 69.1?
Yes, and then you went on to say the tribunal has something about the High Court.
Yeah, then 69.2, the special tribunal is a court with status similar to the High Court, as defined in section 166 brackets small e of the Constitution, capable of granting relief in section 172 of the Constitution, which is what we're asking your ladyship in the second part of this case. Paragraph 7 of our amended notice of motion. Then 69.3 of the judgment, I'm still quoting, Section 2(1)(b) read with Sections 8(1) and 8(2) of the Act, as well as Section 166 brackets E, 170 and 172 of the Constitution, actions based on its alleged constitutional invalidity. And we submit, my lady, the reasoning is sound, and your ladyship is bound to follow it on the usual basis of stare decisis. I think that's how you pronounce it.
Mm-hmm. In any event, would this tribunal not be bound by that decision until it is set aside?
Well, it's either that or your ladyship is persuaded that it's clearly wrong.
Mm-hmm. Or can be distinguished.
Or distinguishable, my lady.
Mm-hmm.
And then we submit, my lady, that Caledon has subsequently been followed in SIU versus Zakheni, Zakheni, Strategic Supplies Pty Limited, and another brackets GP09/2021 close brackets, then open square brackets 2022 ZAST 16 brackets 29 June 2022 at paras 36 and 37. And again, Judge Modiba, where she says, on the Supreme Court of Appeals authority in Madison, which I referred your ladyship to, and this tribunal's authority in Caledon River, the tribunal is a court of law with the status of a high court, as envisaged in Section 166, brackets E of the Constitution, with constitutional jurisdiction. And she proceeded to dismiss those points also, my lady. Now, Mr. Satsawani also submitted that the tribunal is not a tribunal for the purposes of PAJA. We don't have to deal with that point because we've never contended, my lady, that it is. For the simple reason that the SIU's review in this matter is pursued not in terms of PAJA, but is a legality review. And we submit that PAJA is not of application. We're going to deal with that second enlightenment point of view is now that we ought to have brought it in terms of PAJA. Again, my lady, this tribunal has decided this point of law, and it goes against the seventh respondent. And we submit that your ladyship will not have been persuaded by my colleague that those decisions are clearly wrong. Species of self-review, and to the extent that Mr. Satswani had relied on Nkajima, we submit that Nkajima must be read bearing in mind the introduction in that case which obviously informs one's reading of the remainder of the judgment. And I quote, we must emphasize, this is in Nkajima, in paragraph...
Which paragraph?
Paragraph 2 of the Nkajima judgment, my lady. Whether the court in advance is cautioning the reader what this case is actually about. We must emphasize that the issue has nothing to do with a scenario where an organ of state that is in a position akin to that of a private person, brackets natural or juristic, may be seeking to review the decision of another organ of state. Nor are we concerned with a situation where, in seeking a review of its own decision, an organ of state is purporting to act in the public interest in terms of Section 8 of the Constitution. Those questions are not before us. Close quotes. We submit, my lady, the SIU, its review is akin to a self-review. It is not a private party reviewing the decision of the state. Yes, my lady, of course, its mandate is a public interest one, but it's a statutory duty that it has in terms of the law, a law which has not been declared unconstitutional. So to that extent, the SIU would litigate on behalf of 15 and 16, in this case, even 17, on all our behalves, because it's public money. But it doesn't litigate in the public interest, for example, for the purposes of Section 8 of the Constitution. It derives its power from the SIU Act. Did I say 8 of the Constitution? Sorry, my lady, Section 38 of the Constitution. So later on, we'll submit that Ms. Hunter's case against the Financial Conduct Authority, and those cases are not applicable. They're not relevant. At paragraph 27 of Nkajima, the Constitutional Court held that Section 33 of the Constitution, quote, is primarily concerned with everyone's right to procedurally fair, reasonable, and lawful administrative action. Is everyone, quote unquote, in this section so wide as to extend to the state? We think not. This is still the quote from the Constitutional Court. Section 33B provides that national legislation, in terms of Section 33, has given effect to the Section 33 rights, must impose a duty on the state to give effect to the rights in Section 33 and 32. It seems inconsonant that the state can both be the beneficiary of the rights and the bearer of corresponding obligation that is intended to give effect to these rights. This must indeed be an indication that only private persons enjoy rights under 33. It is there to protect private citizens, my lady, against overreach on the part of the state. So, when a decision is made that constitutes administrative action, you're not allowed to put up a building, you're not allowed to demolish a building, you're not allowed to drive your car in a particular road. The private citizen is entitled to challenge such decisions, but of course the private citizen, my lady, wouldn't be typically aware of what informs the decision, meetings held, documents that were submitted in these meetings by state officials, and how they arrived at the decision. That is why they bring the application typically under PAJA, and they use Rule 53 so that they can get a record of the decision. And then in terms of Rule 53, you get an opportunity to amend your notice of motion, amend your founding affidavit, and file a supplementary affidavit if you wish to do that. Or, of course, you get the opportunity to withdraw your application because it seems that as if the decision was fairly made or properly made based on the record that you've been provided. This is nothing like such a case, my lady. So we go on to say, my lady, that the SCA appears to have agreed with these propositions and held in SIU versus Engineered Systems at paragraph 25 that, and I quote, "It seems doubtful that the SIU would be regarded as being in a position akin to that of a private person." And then it refers to that quote that I read in Kajima, where the Constitutional Court said it seems inconsonant that the state can both be the beneficiary of rights.
You're referring to the Engineered Systems case?
The engineered.
What is the citation there again, Mr.
I'll get it for you now, my lady.
Okay.
And where, just to complete the quote, while Ms. Fries gets me the citation, that this is in the SCA paragraph 25. This must indeed be an indication that only private persons enjoy rights under section 33. My lady, the reference is, the JUTA reference is 2022 brackets 5 SA 416 brackets SCA.
Thank you.
And it was decided on 25 June 2021.
Thank you, Mr. Arendse.
So, my lady, we submit that Mr. Satwani's reference or reliance on CompCare, CompCare and Hunter, referred to in paragraph 4.17 of the heads, is completely distinguishable. In both those matters, my lady, the persons reviewing were seeking to do so based on section 38 brackets D of the Constitution, i.e. they were doing so in the public interest. The SIU doesn't need to do so, my lady. It has its own act to follow, as it were. Then, just on this point, lastly, my lady, the tribunal relied upon Nkajima to confirm legality reviews in the following two cases: Special Investigating Unit versus MEC for Department of Treasury, Free State Province. That reference, my lady, is brackets FS01/2020, close brackets, and open square brackets, 2022 ZAST 2, brackets, 31 January 2022, paragraphs 32 and 33 of that judgment. Importantly, here the tribunal held that consistent with the statutory regime, the SIU is only entitled to the relief to which the organ of state allegedly implicated in the incidents enumerated in section 2.2 of the SIU Act is entitled. This would mean it can only bring review proceedings under legality. And then the second case, my lady, is SIU versus Patalizwe, PHATHILIZWI, Training Institute and another, brackets EC06/2020, close brackets, open square brackets, 2022, close square brackets, ZAST 11, brackets 11 May 2022 at paragraph 11.
Sorry, what is ZAST 2?
Sorry, ZAST 11.
11. 11 and the date?
And the date is 18 May 2022, my lady.
Thank you.
So just to round off that point, my lady, and why, again, as a matter of almost common sense or self-evidently, why the SIU wouldn't be expected to bring a review under PAJA. Because hardly ever will the SIU be able to comply with a 180-day limit on bringing reviews under PAJA. Simply because the SIU, firstly, would only be appointed by proclamation by the president months, in some cases a few years, like in the engineered systems matter, to investigate alleged corruption, fraud, or whatever, and to investigate a Department of State or a unit of so that will only come some time after 180. And then after the president issues the proclamation, now the SIU investigates. And your ladyship would have seen just from the record in this case that this is not an investigation that's going to take 3 months. Given the volume of paper involved, given the number of people involved, the number of officials that has to be interviewed, etc. So almost inevitably, the SIU will have to rely on legality reviews they're just going to never make the 180-day threshold. If I may move to the next point, my lady, Mr. Satwani submitted that because of the delay, the seventh respondent is suffering prejudice in the form of not being able to bid for tenders because they are now cited as a respondent in this case. We submit that there's no basis for that submission. There's been no decision by this tribunal. The review was pursued in December 2021. And we submit that any delay between the alleged unlawful decisions of March or April 2020 and the institution of these proceedings in December 2021 could not and does not affect the seventh respondent or any of the other parties' ability to tender in the intervening period. And if, my lady, some interested party in another tender where they are bidding mentions their involvement in this case, then it's purely out of mischief and it's no legal basis and it's got nothing to do with the SIU, my lady. The SIU is not the decision maker here, my lady. It wasn't aware of the unlawfulness of the decision that was taken back early in 2020. And as I said, inevitably, there'd be a delay in the SIU bringing review proceedings only after the proclamation was issued and the investigation took place. And my lady, we submit that the clock started ticking in August 2021. and the review was pursued 4 months later. We submit the lady within a reasonable period of time. Then to move on to the merits aspect of Mr. Satswani's submissions, he contended that the process wasn't properly articulated by the SIU. In particular, he said that the 50 million renovation price was not correct, as this was just said in passing during a site visit, and that the person who attended the site visits were not experts. My lady, we deal with this in the founding affidavit at 078.
Just a minute.
078-58 to 078-59 at paragraphs 105 to 109. And we point out...
Just a minute. Thank you.
And,
yes,
and on the papers, my lady, they do not allege that no expert attended the inspection. Their response is at 09562 at paragraph 136.1. Where they say, my lady, that they've got no knowledge of the factual aspect of the procurement process and the alleged representation and omissions between the various provincial entities. And all they do is to express surprise that a certain Mr. Maluleki was aware of the estimated budget of 50 million rand, as he is alleged to have authorized costs and payments, which they say at 095-63, paragraph 137.2. We submit, my lady, the documents speak for themselves, as Mr. Maluleki did make the memorandum that's referred to in the founding affidavit at 078-60 in paragraph 111. And also, my lady, the minutes reflect that a number of representatives of GDOH and GDID were present at the site inspection. That your ladyship will find at 028-493, 028-495. So, my lady, although if you look at those pages, the titles of the persons present at that site visit are not indicated. The seventh respondent doesn't state that they were not experts. So, my lady, that the prices only went up when, as it was submitted, it was established that major refurbishment was required cannot be of any assistance to the respondent, as the appointment was made in March, but contracts were only signed in June. And they were already on site since April 2020. So only once there, my lady, the contractors could tell GDID what work was required and draw up their own specifications. Why? Because there was no scope of works originally, or bills of quantities for that matter. In other words, my lady, both the PSPs and the contractors were given free rein, a blank check to determine prices for themselves. Then, my lady, Mr. Satswani made a submission, which we submit, that is not in accordance with the law or the facts, that in an emergency, no competitive process has to be followed or is required to be followed. We submit that the case law doesn't support that submission, and we refer your ladyship to the case of Chachulani.
Just give me 1 minute, just a minute. You say that it's not in accordance with process or law, that in an emergency the procurement process doesn't apply.
Yes, it's not supported by the case law. The case is Chachulani Group Investment Holdings. Sorry, SIU v. Chachulani. Does your ladyship want the reference?
If you can, yes. And that's mentioned in the heads, but there's just so many heads, it would just be easier for me to.
It's cited by quite a few. Brackets GP 15/2021. Square brackets 2021 ZAST 1 brackets 14 August 2021 at paragraph 59. And then we say also the National Treasury has never permitted this. And our reference point, my lady, is in our founding affidavit at 078-55 to 078-56 at paragraph referred to Treasury Instruction Note 7, which is 2020/2021, which specifically requires that the constitutional principles of public procurement must be maintained. Then moving on to second last of the submissions, we submit the fact that the contracts were awarded in excess of 500 million by the department doesn't assist the seventh respondent. There's no need for the SIU to review and set aside each decision. We ask for the leases and the appointments and contracts all to be set aside. And the reason, my lady, is quite straightforward. The SIU's case has been that the entire procurement project was irrational. And your ladyship will recall that not one of the respondents have challenged the irrationality of the procurement process. And we submit, if your ladyship adopts this finding, as we say your ladyship should, then everything in connection with this project must be set aside. And we add that in any event that the GDOH project manager, Mr. Koloi, Q-O-L-O-H-E, excuse my pronunciation, my lady. And your ladyship will recall he filed a confirmatory affidavit that said that the full amount was not paid because there was no approval for it. And that your ladyship will see in the founding affidavit at 078-96, paragraph 172, and that is not disputed on the papers.
So 078, 96, and 102.
Yeah, 078-96, paragraph 172. Then lastly, my lady, in relation to the seventh respondent, we do not need to show any misrepresentation on the part of either the seventh respondent, my lady, or any of the other respondents to obtain just and equitable relief in the form of the no profit principle. And that applies to all the other respondents, my lady. They all, I think across the board, claim that they are innocent in this matter. And there was no fraud or corruption. We didn't, the SIU may have mentioned that, I'm not saying exactly that, but it may have mentioned that initially in the preservation application. But certainly they haven't pursued fraud and corruption charges against any of the respondents. Our case is purely that the whole project must be set aside because it was unlawful and unconstitutional on the grounds inter alia of irrationality. That's on the first part. On the second leg, on the just and equitable relief, which I've already pointed out to your ladyship, this court may grant under section 1772, is that they shouldn't profit from an unlawful contract. And the authority for that, my lady, is strong authority.
Just a minute. Sorry, what is the authority?
Yes, authority is the Constitutional Court in All Pay 2. There were two cases, All Pay 2. Do you want a reference to that?
I think it's in one of your heads. I'm sure I'll find it.
It is there, my lady. And then also the SCA in the more recent case in Siangena versus Prasa. Yeah. Siangena versus Prasa, I think, was reported on Saturday, 1 November 2022. And that is authority for the proposition that where a contract has been concluded in a manner inconsistent with the law, i.e. unlawfully, it will generally not entitle innocent parties to benefit or profit therefrom. And as I said earlier, my lord, my lady, this doesn't mean that the respondents will necessarily be out of pocket or that they will make a loss. And I think, as one of my colleagues mentioned yesterday, I'm not sure whether it was Mr. Ellis or Mr. Otis, after that exercise, it may turn out that some of them are owed money. And good luck to them, my lady. Who's the next one? The next respondents, my lady, that I must address is 10 and 13. My lady, just a few minutes comfort break, my lady.
Yes, I said
I will finish 10 and 13 by 1 o'clock.
Okay, it's 10 past now. Say 20 past. We resume at 20 past.
Yeah, that's fine, my lady. Thank you.
Okay, good. We'll take a short break now. Right, good afternoon. Are we all back? Mr. Arunsa? Mr. Arunsa, are you back?
I am here, my lady.
Good. All right, if we can continue then, you were going to deal now with
I'm addressing the 10th and 13th, Mr. Odis's clients. Now, Mr. Odis and several of the other respondents and my colleagues acting for them have tended to align themselves with the submissions of Mr. Satsuwani. We submit, my lady, entirely opportunistically because it's not supported, like with Mr. Satsuwani, not supported on the papers. And in fact, contrary to what's in their papers. And that's what I'm going to point out to your ladyship. The first one that Mr. Odis aligned himself with was the Paja argument. We point out that in our founding affidavit at 078-27 at paragraph 41, the applicant says it relies on the principle of legality to bring its review. And the answers to that, my lady, are revealing. The 10th respondent merely notes this in its answer. The reference is 094-45 at paragraph 126. And the 13th respondent similarly at 096-40 at paragraph 129. But it's even clearer, my lady, in the case of the 13th respondent, because the 13th respondent says that the SIU has delayed in pursuing its review within a reasonable time. That's at 096-25, paragraph 73. It doesn't say anywhere that the application ought to have been pursued within 180 days in accordance with Paja. We submit that they've thus accepted that the legality review was an appropriate procedure to adopt in this matter. Now, in regard to the delay, my lady, the 13th respondent relies on the engineered systems solutions case, which I've already referred to, where the SCA found that the delay was not reasonable. Now, we submit, my lady, that decision is wholly distinguishable from this case. In the engineering systems matter, my lady, the decision or the impugned decision was taken in 2011. The President issued a proclamation.
Sorry, you said that Engineered Solutions found that the delay was not unreasonable.
No, the SCA found against the SIU and said that the delay was not reasonable.
Yes, that was not reasonable, yes.
And we say, my lady, the facts are distinguishable in this case.
Mm-hmm.
In that case, in engineered system solutions, The decision was taken in 2011. The SIU proclamation to investigate was issued in April 2016. And also in that case, my lady, the government department concerned, Correctional Services, was a co-applicant, unlike in this case. The review was pursued in only 2018. And in the SCA points out that at paragraph 41 of the judgment, that the SIU had all the necessary facts ready in September 2016, but still only launched in April 2018 for various reasons. In our case, my lady, the SIU took slightly just more than 4 months, and had then all the facts at hand, and the review was then launched shortly thereafter. And importantly, my lady, whatever the impugned decisions taken in April and May, June, and in the early 2020, obviously the SIU didn't have knowledge of those decisions. It only uncovered all of this following the investigation.
I think the allegation is that they knew as early as, it was Mr. Motibi's letter was November 2020, was it?
Yes, my lady.
Yeah, and I think that is their benchmark, that knowledge on the part of the SIU must be deemed to have run from November 2020. So, you know, that perhaps you want to answer that.
Well, the answer, my lady, without being flippant about it, yes, when the directive is issued in 2020, the investigation must now commence. And it's
saying that the knowledge is not necessarily aligned to when the investigation must commence.
Yeah, it's not like a department, like in this case GDOH or GDI. Not only do they have knowledge because they're the decision makers, they also know, or they are also deemed to know, to have known why they did certain things. And if they want to bring even a self-review, then they have all the information at hand, at their fingertips, or available to them. The SIU, your ladyship will know from the papers, were frustrated in many instances by reluctant witnesses, or witnesses who downright refused to cooperate. And all this, my lady, we submit must be taken into account. So for the purposes of a legality review, where the test is within a reasonable time, we submit that it's not, the SIU didn't delay unreasonably long in bringing these proceedings. So if I may, my lady, move on to the next point. Mr. Oudis submits that the respondents, including his clients, they oppose the two types of relief, as he puts it, the legality and the disgorgement relief. But he continued that if the one succeeds, the other does not, and that there are cost implications for this. But we point your ladyship to section 172 of the Constitution, and this has also been referred to in the other tribunal cases that we have referred to, being Pataliswe and another one, where there's reference to Section 172 of the Constitution, and that this tribunal has jurisdiction to decide matters in accordance with 172 of the Constitution. That section reads as follows: when deciding a constitutional matter within its power, a court A must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of the inconsistency, and B may make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of validity, and 2, an order suspending the declaration of invalidity. That's typically in the case of legislation to allow the competent authority to correct the defect. So we submit, my lady, that if the SIU does not succeed in having this tribunal declare the conduct of the GDID and GDOH inconsistent with the Constitution, that would obviously be the end of the inquiry. But if it does succeed, my lady, then this tribunal, in accordance with 172, has to consider whether it is just and equitable, that a just and equitable order be made, and that the submissions of the applicant and the respondents are relevant to that aspect of the case. And the authority, my lady, is the SIU v. the National Minister of the Department of Public Works.
Just a minute.
The reference is...
Just a minute, Mr. Evans. Right, case is what?
The reference, it's the SIU versus National Minister in the Department of Public Works, and another, brackets GP 11/2021, close brackets, square brackets 2022, ZAST 19, brackets 26 August 2022, at paragraph 130. We submit, and that's the authority, my lady, the tribunal cannot ignore the just and equitable part of Section 172, either in these proceedings or in any later proceedings. Submit that because the 10th and 13th oppose the invalidity part, if the SIU succeeds in obtaining such an order, we should still be entitled to our costs, even if no just and equitable relief follows. Then, my lady, to move on to another aspect of our reply, it's in relation to the expert report and Mr. Hodis's criticisms of it. He repeated that no report was available or made available to the respondents when these proceedings commenced, and they were prejudiced because of the manner in which the case was pursued, i.e. by not following Rule 53. This prejudice which he alleges, my lady, is not entirely well explained to us anyway, but we submit they are just wrong. for the following. Firstly, my lady, in the urgent ex parte preservation proceedings, which did involve the 13th respondent, a preliminary expert report was already at hand, and overcharging in excess of 60 million was found. Does your ladyship want the reference?
No, it's fine.
I don't think it's necessary, my lady.
Yeah.
This was the report by, forget their full names now, by SCC, who later refused to commit under oath when they made the report available to the SIU after being commissioned to do so, which then meant that the SIU had to obtain another expert report, and in this case, Ms. Matara's report. And we deal with that in the finding affidavit, my lady, at 078-26, paragraph 38.3, where Mr. Du Toit for the SIU says that a new expert report will be required, and that the full report will only be available in December 2021. Sorry? It won't be. Sorry. It won't be ready by December 2021. My apologies, my lady. When the review was required to be launched by virtue of paragraph 2 of the order of this tribunal of 17 September 2021. So the finding affidavit, my lady, at paragraphs 174 to 176 explains
The founding affidavit.
The founding affidavit is at 078-97. And at 98, the SIU explains that Ms. Matara was appointed in November 2021. And the report, which is at 078-545 to 583, marked FA 47. 545 to 583. It's marked FA 47. And in that report too, the sum of 100 million rand is said to have been incurred as a result of overcharging. So at December 2021, my lady, Mr. Du Toit said in his founding affidavit at 07899 to 078-100 that the final report was still work in progress, and that what was envisaged were action proceedings to establish just and equitable relief. That was in December 2021. Then there was a case management meeting in February 2022 when the respondent said the SIU had not followed Rule 53.
So I think you did refer to that earlier,
yes,
in your opening address, yes.
Yeah. And then the tribunal president expressed her concerns and so on. The tribunal then asked how much longer the SIU would need to finalize the report, and the date of 8 March was then stipulated and complied with. And subsequently, my lady, the respondents were allowed numerous extensions to file their answering affidavits, and most of them did by the 29th of July 2022. This nearly 4 months after the report was provided. And of course, in the end, we know that only 2 of the respondents filed expert reports. Just mute. Thank you, Melody. Yeah, so the point we make is, Melody, that if there was prejudice, it was cured by the many extensions requested, mainly informally between counsel and the lawyers, and obviously subsequently condoned by the tribunal. And once the report was ready, my lady, and having regard to the Judge President's prima facie views and the respondents' complaints in regard to Rule 53 not being followed, an amended notice of motion and a supplementary founding affidavit was then filed on the 5th of April 2022. Importantly, my lady, no new cause of action was introduced in the supplementary founding affidavit. And so we point out, my lady, from the initial preservation application, it had always been SIU's intention to claim either repayment of overcharging and or disgorgement of profits from the respondent. We submit, my lady, that the rules of the tribunal permits it to follow its own procedures. In this regard, we refer to Rule 28.2. I'm not sure, my lady, the sake of time, do you want me to quote that, or you?
No, I've actually got the rule, so it's fine. Just tell me which rule it is. So you say Rule 28.
Rule 28 brackets 2. So thus, my lady, we suggested alternative just and equitable relief in the form of either payment of amounts by which an expert determined the respondents who have overcharged, or by way of disgorgement of profits.
Yes.
Where unopposed or boldly disputed, the tribunal may regard the independent expert evidence as conclusively establishing an overcharge in the papers. Where challenged and the tribunal is not satisfied, then we say that the rules provide for referral to oral evidence, or by way of a statement and debatement, which is what we ask now in these proceedings, procedure to determine the profits made by the respondents. And the authority, my lady, for that, where it's been done in this tribunal, is the matter of SIU v. Fikile in Pofana. The Zakeni matter that I referred to earlier, the MEC for Treasury, Free State Province, and others, and in the Caledon River matter. The decision of 8 March 2022. So the point, my lady, is that your ladyship has wide powers acting under 1721B of the Constitution and its rules to make a determination that is just and equitable. Now, Mr. Oudis makes the point, and I think, to be fair, I made it earlier, my lady, that work done by the respondents cannot be undone. We accept that. So our case has never been asked for it to be taken back or given back or tendered back or any sort of restitution. So if any of the parties, my lady, as innocent as they claim to be, can account for the expenditure, they should have no difficulties participating in a statement and debatement procedure. But if they did profit from, well, in this case, we can't claim ill-gotten gains, but from an invalid contract, then it must be repaid in accordance with the all pay to principle. As we know, the old adage, my lady, is that all of us are presumed to know the law. Or put another way, ignorance of the law is no excuse. So when you get a phone call, my lady, to say, oh, there's a nice juicy contract for you. Are you available? Because I see your name is on the panel. Of course, you're going to say yes and all that, but you know, and you don't want to look a gift horse in the mouth. Well, I'm not saying that they were on the panel, but they participated in the project. It might seem like Christmas or Labarang has come early, but you must know, especially the respondents who all profess to be experienced and have been working in the construction industry for many years, that there's now procurement, there's tenders, there has to be fair and equitable and so on, my lady. So just to move on a bit quicker to the next point, my lady, which is on joinder. We submit that where they've submitted that the officials concerned must be joined, we submit that that is not the test. The test is whether they have a direct and substantial interest in the matter, and whether any findings, rulings, judgments will have any legal implications for them. Certainly not arising from these proceedings, my lady. The fact that they already face, some of them facing disciplinary action, that's another matter, my lady. The fact that they may have knowledge of the facts and so on doesn't constitute a direct and substantial interest in the matter. Then the next submission is to deal with the submission that the 10th and the 13th respondents were appointed legitimately and it was above board.
Just a minute.
Sorry, my lady?
So just give me 1 minute. I'm just finishing up the last point. Yes?
The next point, my lady, is Mr. Ody's submission that the 10th and 13th respondents were appointed legitimately and that it was above board. Now, the panel of contractors on the GDID panel numbered 172. That your ladyship will find at 028-841 to 028-855. Only the 11th respondent my lady, was listed on that panel. And your ladyship will see that at the founding affidavit 078-079, paragraph 134.
078 dash?
Dash 79.
Oh, 79. Mm-hmm.
And it's paragraph 134.
Mm-hmm.
And yet, my lady, Mr. Tabani of GDID phoned the 10th and 13th respondents to inquire as to their availability to conduct works on the AGA, on the hospital project. Again, the kind of questions that necessarily follow from that, my lady, is how we knew that these entities existed. Remember, they're not on the panel. Who the representatives were, what their contact information was, or even their CIDB ranking was never explained. Your ladyship will see that allegation in the founding affidavit at 078-80, paragraph 135. And then the email itself from Tabani is at 028-588, paragraph 3. And of course, we know, my lady, the 10th and 13th respondents haven't volunteered the information to us or to the court. We submit, my lady, and this is an inference we submit, can be legitimately and fairly drawn from that fact that they received a phone call, that if you receive if a contractor receives a phone call from a State Department just out of the blue, never having participated in a tender process, or certainly not recently, because now we just, it's COVID, and then obtains an appointment based on a one-page letter, we submit that any claim that the appointment was above board cannot be a legitimate claim. Then, my lady, as to
Just a minute. Yes.
Then onto another aspect, the 12.13% profit. This percentage of 12.13%, my lady, wasn't determined by their expert as alleged. But
they're meaning the 10th respondents.
Yes, my lady. It wasn't a markup determined by the expert, but it was actually a markup which they applied. Your ladyship will see that at 094-813 at paragraph 177. Mr. Oudis then went on to submit that Ms. Mutara's report lacked any credibility when compared to that of Mr. Stewart's, the other expert, and could not be relied upon despite being on the same facts. But we point out, my lady, but this is simply not true, and it's not the case. Mr. Stewart was provided with all the 10th respondents' documents pertaining to the project, which he lists at paragraph 15 of his report, which includes pricing and statements. And the reference, my lady, is 094-773 to 094-734.
Sorry, 773 to 734.
Yes, at 094. 733, sorry, 733 to 73.
Okay.
Yeah. Now, Ms. Mutara had none of these documents, my lady. And of course, your ladyship will recall from the evidence, unchallenged, that Mr. Du Toit, the SIU investigator, in his reply said that the respondents were approached on 4 occasions during site meetings or inspections for their versions. They all declined. The reference, my lady, is at 100-101, paragraph 409. Then, my lady, Mr. Otis then goes on to deal, or his next submission is that the absence of an expert report on behalf of the 13th respondent is of no or of any particular moment, because all the respondents are experts in their field. This again, my lady, self-evidently cannot be correct, let alone factually correct. For a start, unlike the requirement, the key requirement for an expert, they're not independent. But worse, my lady, in the case of the 13th respondent, your ladyship will notice that the deponent is Miss Tenga, who describes herself as a businesswoman and who deposes to the affidavit as the persons involved in the project with her husband, who, my lady, sadly passed away in July 2020, and one Mr. Mtetwa, who left the 13 respondents' employ in May 2022. Your ladyship will see that reference at 096-11, paragraph 4. So the point that we highlight, my lady, is that the deponent herself, Ms. Tenga, was not even involved in the project. And she's a businesswoman. So it's just quite... I don't know if this is an English swear word, my lady, but it's just quite preposterous to say that Ms. Tenga is an expert in the field of construction. Then Mr. Otis goes on to make the same submission or similar submission made by his colleague, Mr. Satsawani, which is not based on the papers at all, that the persons who attended the initial site meeting where the 50 million rand budget estimate was mentioned were not expert. This is dealt with, my lady, in the founding affidavit.
Just give me a minute.
This is dealt with in the finding affidavit, my lady, at 078-58 to 078-59 at paragraphs 105 to 109. If your ladyship looks at the 10th respondent's answers, it doesn't allege that no experts attended the inspection. All it says that the persons identified ought to have been joined in these proceedings. That your ladyship will see at...
Are you talking about the 10th or the 13th respondent?
The 10th
Okay.
respondent.
Because we were dealing with the 13th respondent, so I'm just wondering.
Moved on a bit now. So that your ladyship will see at 094-46 to 094-47. And the response of the 13th respondent is actually the same at 096-41, 096-42. So Mr. Otis' submission is not borne out by the papers. So, my lady, those are our submissions in answer or in reply to the 10th and 13th. We now move on to the 11th. Mr. Ellis. Mr. Ellis also, my lady, aligned the 11th respondent with the arguments of the 7th, despite not having raised the jurisdiction of this tribunal or that Paja applied in the papers. When the applicant says at paragraph 41 of its finding affidavit that it relies on the principle of legality, the answer of the 11th respondent is simply denied, but they don't take it any further. So, Mr. Ellis points out that it's ironic that the first and second respondents would get off scot-free, as he put it, and that no just and equitable relief is sought against them. Now, for present purposes, that would be a fair statement to make. It's a correct statement, not perhaps fair, but it's correct. But we do deal with it, my lady, in the replying affidavit at case lines 100-48 to case lines 100-50. Where we say that the SIU is empowered to claim repayment of monies from those it can demonstrate has been overpaid or who have profited. At the time when these proceedings were launched, the SIU was unable to make such a case against the first and or second respondents. The lease terminated in January 2022. And since then, the GDOH and GDID had been in negotiations towards acquiring a further right of occupation in respect of the premises it had spent in excess of 500 million rand on.
I think I must stop you there before I forget the point. And if I recall correctly, the context in which that was said as well is that how would you calculate the loss if, for instance, there's negotiations now with the first and second respondent and you're going to get a lease? Would you be able to say that 500 and let's call it 550 million is in fact now recoverable from the other respondents, or should there be a subtraction because your loss would be reduced if you now either get the donation or get a further right of occupation of the hospital? I think if you could just bear that in mind because I recall that to be about the context in which Mr. Ellis made those submissions as well.
No, my lady, we
Oh, you're frozen up there, Mr. Arthur. I didn't hear you.
Can you hear me now, my lady?
Yes, now I can hear you.
Yeah. My lady, we have taken that into account, and it's a fair question because that is why it's not appropriate for your ladyship, for this tribunal, to try and figure out what the rands and cents should be at the end of the day, because this requires other experts, valuation experts, and people involved in the property market to do all kinds of sums and calculations and so on, and work that out, my lady. Thank you, my lady.
So just give me one moment. Just give me one moment. I'm just recording. I'm summarizing your response. Mm-hmm. Yes, you may continue.
Thank you, and I'm also indebted to Ms. Friest for pointing this out to me. In any case, my lady, this was a free lease. No state monies was expended in fact securing or obtaining the lease. So as we speak, there's no loss to the state there. It's only in relation to perhaps some kind of an enrichment claim because the facility was improved and is now worth more than what it was when the contractors started making renovations, that those calculations will have to be made, my lady. And it's an aspect or an angle that we considered, but ultimately decided not to pursue in these proceedings.
And by extension or logical extension of that idea, if your negotiations fail, then I imagine you will pursue action against the first and second respondent.
Yes, my lady. The sensible approach would be to negotiate a settlement acceptable, hopefully, to all parties concerned. And of course, my lady, just on this, we know that the sixth respondent, for example, has pursued a conditional counter application against the first, which is being opposed. Maybe that's why they want to be here, Malay.
Right, you may continue.
There was nothing stopping the other respondents from doing the same, or perhaps still doing the same.
All right. Sorry, I interrupted you. You may continue.
Thank you, my lady. Then, my lady, Mr. Ellis made the submission that there are irresolvable disputes of fact on both the legality as well as the overcharging. And we submit that submission is wrong. In respect of the legality, the 11th respondent doesn't explain anywhere what these alleged disputes of fact were. But we assume that this refers to submissions that an internal misrepresentation of the estimated costs of the project, some 50 million, can.
Oh, you're frozen up again, Mr. Arendse.
My lady, I'm dealing with the submission by Mr. Ellis that.
Yes, now I got all of that. What you said is that they didn't explain what the illegality disputes are, but yes, you assume that.
We assume that they refer to submissions that an internal misrepresentation of the estimated cost of the project of some 50 million cannot be visited on the respondents. But we submit that this is incorrect. Not only was the cost estimate known to the 11th respondent itself, and our reference, my lady, is in the reply at 100-127, paragraph 476. But it ignores the fact that both the PSPs and the contractors, and of course, as we know, my lady, it is the contractors who are the ones who populated, i.e. filled in the figures on the bills of quantities. They were already on site and had commenced work, and only at that stage were required to determine the extent of works and the price. That's our argument advanced also earlier, my lady, that they were given a blank check. The SIU's architectural expert states that the starting point under what is called the Framework for Infrastructure Delivery and Procurement Management is a client/user brief being provided to the architect. In this case, my lady, no client end user brief was provided to the architect. If we've got a reference for that, case lines reference. I just have it, 4.1, 6.1.
Yeah.
I'm just asking Ms. Fries for the case lines reference because I've just got a reference to paragraphs 4.1, 6.1, and 7.1 of that report. That is the one attached to Ms. Matara, so it's 87 somewhere. So the point is, my lady, that effectively the PSPs and the contractors determined this for themselves.
Oh, 87134.
087134.
Mm-hmm. To 087137.
To 087137. Thank you.
Thank you.
So, my lady, we move on to another point, and it's a point I touched on already, that at the outset, when I said of my address, when setting out the common cause facts, We subsequently have not heard any of the respondents attempting even to justify or to gainsay the irrationality of the project and the cost increases and the appointment process. The 11th respondent, while indeed on the GDID panel of contractors, we point out that there were at least 150 other contractors. Again, the rhetorical, self-evident questions. Why was it only the 11th respondent that got the appointment? How was it made? Why weren't any of the other contractors approached? And if they were, why did they decline? Again, it's a statutory duty as the SIU to point out that at least some, if not all of the other 150 contractors didn't have a fair shake, weren't treated fairly in respect of this publicly funded project. And it's our duty to bring this to the attention of this tribunal. And arguably, my lady, there was every possibility that if other contractors were approached, they may have done the work more cheaply. But that's in the realm of speculation, albeit not unreasonable. Now, Mr. Ellis submitted that negotiations took place, as he put it, insofar as it was possible. He never explained this submission, what it means.
Sorry, just repeat that submission again.
Mr. Ellis submitted that negotiations took place, quote, insofar as it was possible. But he never...
Oh, I see. You mean in relation to the contract of the 11th respondent?
Yes, my lady. But this is what we do know, my lady. We know as a fact that the 11th respondent was appointed without a contract price or scope of works. And we know for a fact that the 11th respondent started or commenced work on the project while these terms had not been finalized. What further facts, my lady? The 11th respondent, it invoiced and was paid in April, May, and early June. 5 invoices amounting to in excess of 20 million rand. That your ladyship will see at 078-95. And crucially, my lady, that was before they signed the contract. So what a pleasure, my lady, to negotiate insofar as is possible when I've already got some 20 million in my pocket and I'm on the job. And as I'm respectfully submitted earlier, GDID and GDOH were now dug themselves into a hole because these contractors were now on site and begun to do work. I know Mr. Ellis said that this is usually how things happen in the construction industry. I have, maybe he's an expert, but I'm not, my lady. But I do know of a house that I had built. And I would be horrified to think that the builders started digging a hole and building my house without even knowing what I'm in for, my lady. And we're dealing with public monies here. That's quite telling. Then further, my lady, they knew the contract price was 50 million as at 22 April 2020. And the reference, my lady, is 100-127 at paragraph 476. Read with annexure AA 30, which is at 091-193 to 091-196, particularly at 091-194. What we also know, my lady, is that the scope of works increased. According to the 11th respondent, there were some 6 versions of a bill of quantities. Now, to the extent, my lady, or let me rephrase, the red lights were flashing. The project appeared to be running completely out of control because the third respondent was asked, as the project manager, was asked to reduce costs from 866 million to 647 million.
Just a minute.
The third respondent was asked to reduce costs from 866 million to 647 million, actually down to 588 million. But, my lady, this was not reduced by way of negotiations, as we are led to believe, but was based on an instruction from GDID by asking that the health technology items be omitted or be removed because it was going to be procured elsewhere. And then there was the agreement, as I pointed out earlier, only in June, to cap PSP fees at 19%. So we point out, my lady, this was no negotiation, and certainly no negotiations on the part of the 11th respondent, who was the contractor. Our reference, my lady, is 100-33 at paragraph 72. Mr. Ellis also went on to say, my lady, that the 11th respondent was not appointed by virtue of the appointment letters of March and April 2020, but was on site early in the hope of acquiring the contract, i.e., it was on site early on risk. But we submit that this submission is completely contrary to the papers before your ladyship. The reference...
Just a minute. Just a minute.
The first reference, my lady, is at 091-24, at paragraph 35 of the 11th respondent's answer.
At paragraph 35.
Yes. The 11th respondent, it says the third respondent was informed that it was the contractor for LOA 3 and its site establishment was to commence from 9 April 2020. Then the next reference is at paragraph 61, I91-32. As at 26 April 2020, the project manager had written to the 11th respondent and noticed that it was 2 days behind on its construction program, and it was asked to expedite the works. And we submit it would never have had a construction program had it not yet been appointed to perform the works. And in fact, my lady, it invoiced and was paid for work done from April to June 2020. That's at record 078-95. Mr. Ellis also went on to...
Just give me a moment, give me a moment.
Thank you.
Thank you. Yes, may continue.
Mr. Ellis also submitted that overcharging must be proved by way of considering the scope of works and not the bills of quantities. But your ladyship will know in this matter, the problem is that no scope of works was provided in the first place. And this stands unchallenged and certainly was not challenged by the 11th respondent's expert appointed by them. This is in fact what their own expert says, my lady, at page 3 of his report, which is at 091-1600, that, and I quote, Motara's assessment of the bill of quantities, specifically referring to the specification and details included and the comparison between the work packages, could be seen as fair and accurate.
What paragraph is that, Mr. Aronson?
That is at page 3 of the 11th respondent's, Mr. Stewart's expert report, which is at 091-1600.
Okay. Thank you.
So, my lady, so much for Mr. Ellis's claim that the expert annihilates Ms. Motara's report. Then another aspect which was criticized, but which was dealt with, my lady, in response to the third respondent's argument, which is the comparison of the hospital prices. Just in addition, my lady, if you could just flag this, Ms. Motara's reply and Ms. Motara's calculation is at 100-132 at paragraph 493.4, where the price per bed at the hospital, my lady, AGA hospital, the one we're talking about, was in excess of 3.1 million rand compared to 3 other state hospitals in Gauteng. And so that was at least, or not less than 3 times the cost. Then just lastly on Mr. Ellis's argument relates to the statement and debatement, which he submits is not an appropriate remedy because there's no legal right to it. Because of the old Roman Dutch law, my lady, uberima fideis, a fiduciary relationship between two parties. But my lady, we're relying on the Constitution, section 1721B, which provides for your ladyship to order or determine a just and equitable relief. In any case, and I don't think I need to dwell on it or it should take much of your ladyship's time. Even on some of the cases I read in statement and debatement, a third aspect of it, even though there's no relationship between the SIU and fiduciary relationship between SIU and the respondents, the SIU also has a statutory duty to require the court to make such an order, my lady. And we've already referred your ladyship to the Mpofana matter, where this was decided, and also in the Zakeni matter. I don't know if your ladyship wants those references again.
No, it's not.
Mpofana is at paragraphs 29 to 31, the judgment, and Zakeni 39 and 40.
That's the reconsideration judgment, preservation judgment, or the reconsideration judgment. I think it would be the reconsideration judgment.
Sorry, Maria.
I think that would be the reconsideration judgment where that was canvassed.
I'm a cricketing person, my lady. I'm out of my crease on that one. Ms. Fries is just checking the DRS.
And I think it was the reconsideration judgment. It's paragraphs 39 to 29 to 31 for Mpofana.
31 and Zakene 39 and 40. And the point we make is, my lady, that Mr. Ellis or the 11th respondent has not contended that these decisions were clearly and wrongly decided. So as a matter of law, my lady, your ladyship is bound also by these decisions unless they are clearly wrong. My lady, we got 6th and 4th.
Yes.
So I will, if I may, again, just ask for a very short comfort break, my lady.
Okay. All right. We will take a short break. I'm sure everybody, 10 minutes?
10 minutes is fine with us.
Or you want 15 minutes? You want to have a quick cup of tea?
Yeah, maybe 15 minutes.
Okay, 1:45. We'll resume at 1:45.
Thank you.
Thank you. Okay, good afternoon, everybody. Is everybody back?
Good afternoon, my lady. Good afternoon, colleagues.
Right, Mr. Aaron, so you're here. I take it everybody else is back. All right, so I'm not hearing any objections to that or any counter arguments to that question. So let's carry on.
Thank you, my lady. We're replying to the sixth respondent. Just at the outset, we mentioned that many, if not most, of the arguments raised by my colleague for the sixth respondent,
Klopper,
was either never raised in their answering papers or is at odds with their answering papers and raised for the first time in his heads of argument. As you know, my lady, and it was condoned that their heads were filed only belatedly on the first day of this hearing. The issue of jurisdiction, which he also latched onto, was never or is not an issue on the papers, not raised in the answering papers. And the same applies to his Paja argument. So our responses, my lady, in relation to both those issues are the same as that raised in relation to my colleague, Mr. Chachawane's arguments. We've already addressed you on the Paja argument.
Yes.
It's not no application here, and that in terms of Section 5.5 of the SIU, the SIU is entitled to bring these proceedings either in its own name or on behalf of any other organs of state. Then the issue of delay, my lady, is only raised in passing by the sixth respondent, and their answering affidavit is at 97-95 to 97-96 at paragraph 180.3. And yet, my lady, Mr. Klopper, in his heads of argument, spends a lot of time on setting out how the alleged delay was unreasonable.
Which you say was not dealt with in his papers.
Sorry, my lady?
Which you say was not dealt with in his papers.
Or not dealt with in his
papers, in his answering affidavit.
It's not dealt with in the papers, my lady. And I've given you the reference. It's 09795, 09796, and at paragraph 180.3.
Yeah, that's right.
The answering affidavit doesn't deal with the allegations made in the argument. And that is why, my lady, no opportunity was afforded to the applicant to deal with those allegations made in argument. And so, for example, the dates and addresses set out in the memoranda and opinions provided by the SIU are not dealt with in reply. And we submit, my lady, that is inherently unfair, and I will refer you to two very well-known authorities in that regard. Now, the first document that Mr. Klopper refers to, and which is not dealt with in answer, is a report from Ezra attorneys, which is at 09737, paragraph 65. Now, that is one of the SIU has never relied on this document, my lady. So, to that extent, Mr. Klopper's submission is factually incorrect. And for the simple reason, my lady, that the SIU did not procure this report, nor seek to rely on it, and certainly didn't rely on it as he submitted in respect of any overcharging.
My lady, may I be so rude to interrupt at this stage? My lady, following from Mr. Arendse's reply to other colleagues, there are many aspects which we believe is not referred to correctly. This is the first point which is not referred to correctly into relation to what my previous arguments are. But I don't want to be rude and interrupt every time such a statement is made. May I indicate from your lady whether I will be given the opportunity to deal with this at a later stage, or whether, because it is unacceptable if statements are made.
Yes, well, I don't want this now to become a re-argument of arguments.
I understand that, Molly.
And it really is, it's counterproductive, it's annoying, and it's just simply a waste of time. So,
Yes,
as far as that is concerned, you've made the submission. I will then check that when I'm doing my judgment and pick up, what is correct and what is not. And I really don't think it's necessary, because you all have made your submissions. He's responding, and I will most certainly be able to check the reply in conjunction with the submissions made by the respective respondents.
My lady, I'm very satisfied with that. I just wanted to point out the issue.
Yes. Thank you, Mr. Klopper. Thank you. Right. Thank you, Mr. Arendse. You may continue.
Thank you, my lady. As far as possible, I think almost at all times, I've referred your ladyship to a reference in the record. And as your ladyship correctly points out, if your ladyship checks the record and it's not a correct reference, then the submission suffers.
I will say so in my judgment, Mr. Arendse.
But my lady, this is also so, quite frankly, outrageous when a party files a heads of argument hopelessly late on the first day of the hearing, and still wants another bite at the cherry, my lady. This is exactly the consequence of that. Is that when you haven't had a fair opportunity of looking at your colleagues' heads of arguments in preparation for a hearing, and you only hears his oral submissions and has to deal with it that way, my lady. So, my lady, in respect of that document, the Ezra attorney's report, and other documents which we will refer to and relied upon by Mr. Klopper, we want to draw your attention to this very, very important rule of practice. The matter is the NDPP versus Zuma at 2009-2 SA 477 SCA at paragraph 47, where the court said this is a judgment of Mr. Justice Hums, as I think at that stage the deputy judge president of the SCA, and of course a well-known authority on the law of civil procedure in this country. He says, it is not proper for a court in motion proceedings to base its judgment on passages in documents which have been annexed to the papers, when the conclusions sought to be drawn from such passages have not been canvassed in the affidavits. The reason is manifest. The other party may well be prejudiced because evidence may have been available to it to refute the new case on the facts. A party cannot be expected to trawl through annexes to the opponent's affidavit and to speculate on the possible relevance of facts therein contained. The position is no different from the case where a witness in a trial is not called upon to deal with a fact and the court then draws an adverse conclusion against that witness. In this case, my lady, Mr. Klopper referred to an annexure to Mr. Du Toit's investigative affidavit, which would ordinarily, as your ladyship would know, be part of a Rule 53 record. That's why when you get as an applicant, when you get a Rule 53 record, you are required, or if you choose to, you can take out parts of that record and put it into your supplementary affidavit or put it into your papers. But you can't simply take the whole Rule 53 record and annex it and say, here with my supplementary affidavit, and next year to see Rule 53 record. It won't be admitted. And then, my lady, when you go to court and argue an opposed motion, and typically in an actual hearing, your ladyship won't see it now, but I think your ladyship has this big fat record there on the side. You have this record on that side, and you have the papers here on this side. You can't tell the court, sorry, my lord, my lady, I'm just going to the Rule 53 record, Annexure Z, just to get it out there to make a point. It's not permitted. This is what's being done here. In fact, the leading authority on this aspect is the very well-known Swissborough case, my lady, Swissborough Diamond Mines Pty and others versus the government of South Africa and others. 1999 brackets 2 SA 279 brackets T, and the reference is at 323 I and J to 324 F. And that's the very well-known, highly respected judgment of Judge Joffe, who himself was also a leading authority in this area of the law, my lady, and has been referred to and relied upon in many, in countless cases. So, in fact, in relation to the unreasonable delay argument, we submit that there was in fact no delay at all. The report which is referred to, which is at 028, and again, my lady, if you look at case lines, which documents are at 028? It's headed discovery notices. It's not really part of the record. 028-1411 is a report prepared by the attorney instructed by the 16th respondent, not the SIU. Now, this report, my lady, already demonstrates serious questions to be investigated, as the 6th respondent rightly points out. And yet, after August 2020, the GDID took no steps. But, my lady, this is not for the SIU to answer, but for the GDID. The SIU cannot compel a State Department to act on a report it knows nothing about. Similarly, my lady, there's a report at 028
Just give me a minute. Sorry, just give me a minute. Okay, you say similarly, there's a report.
Similarly, there's a report at 0281461, which is dated.
You froze up there, Mr. Arendse. Dated what?
2021.
Sorry, what was that date? I didn't hear the date.
28 February 2021, which is an internal GDOH report, where reference is made to a legal opinion. But this, again, my lady, is a legal opinion procured by GDOH, not by SIU. So while the SIU is mentioned in the legal opinion at 0281468, it is referred to in the context of having conducted a site visit. And the reason for that, my lady, is quite simply that by then, the president had issued a proclamation that this investigation take place. So the report, my lady, which is in any event unsigned, doesn't emanate from the SIU, and was not addressed to the SIU. Then, my lady, there is...
Just a minute.
The next document, my lady, is a senior counsel's legal opinion, which is at 0281452. It's a legal opinion of our colleague, Advocate Kassim, and it's addressed to the GDID and GDOH and the State Attorney. It's not addressed to the SIU, my lady. So we submit, my lady, by referring the court to these documents, never and not part of the pleadings, as it were. It's not in the affidavits. In fact, underscores the reason why the SIU had to do something about the abuse which manifests in this case. And that is this: despite these memoranda, despite the legal opinion, GDOH and GDID did nothing to stop the abuse or to have these contracts set aside. And we deal with this, my lady, in our heads of argument at 054-230 to 054-231. Then, my lady, we've already referred to the engineered systems matter, which is an SEA judgment, where the SEA appears to have accepted that the SEA's clock starts ticking, or time starts ticking, to pursue a review only once it has all the necessary facts to hand. And as opposed to the 15th and 16th respondents in this matter, the government departments, who had the facts or should have had the facts at their fingertips a long time ago. The SIU only had the so-called facts in this matter in August 2021.
Mm-hmm.
So we submit that your ladyship will find that this review, firstly, on the basis of the principle of legality, and then secondly, in terms of the time, it has to bring the review on the basis of that principle was done within a reasonable time. Now, then Mr. Klopper made submissions in relation to the existence of the tender process involving the appointment of the sixth respondent, and he submitted that it only came to the knowledge when the answer in the preservation proceedings was filed. We submit that that submission was incorrect. In Mr. Du Toit's investigative affidavit, he refers to the panel of PSPs at 02840.
Just give me a moment, please. Sorry, 028?
02840 to 02841, paragraphs 41 to 44, where Mr. Du Toit refers to the panel of PSPs. And at that time, my lady, the purported extension of the panel was not known to him, and the SIU disputed the contention that any purported extension was lawful. And when it was raised...
Sorry, just a minute. Yeah.
And when it was raised in the reconsideration application, your ladyship, just again, just backtrack very quickly. To freeze the funds of amongst the sixth respondent. And then there was an application for the tribunal to reconsider that decision, which was also refused. So at that stage, when it was raised in that application, the SIU denied that the extension was unlawful, and it's still so denied in these proceedings.
You denied that it was lawful, not unlawful?
Yes, the extension. And these are some of the reasons, my lady, we submit, all compelling. The February 2020 memo, upon which the sixth respondent relies for the alleged extension of the panel, which you'll find at 097149, does not set out any emergency circumstances requiring a deviation. In fact, if your ladyship looks at the memo, it emerges from the reasons given by GDID that the panel was required to be extended for 4 months. And this is the reason, only because of poor planning on the part of those who are supposed to initiate the new procurement process timeously. And crucially, my lady, this was before COVID-19 had even reached South Africa, or maybe officially reached our country. And the pandemic could not and was not used as a basis for the deviation. And we submit, my lady, that the facts are similar to what Ladyship Modiba found in the Patilizwe matter at paragraph 21. In other words, you can't use as an excuse the extension of a panel for one purpose or one reason and then seek to press it into service for another purpose or for another reason. The panel that they were on, which expired in February and which was then extended, was the kind of panel which GDID ordinarily had regard to before COVID. They couldn't now use that as a reason because of COVID to ignore the other procurement procedures that had to be used, because it undermined the whole competitive procurement process that is required, also by the National Treasury regulations. And we submit that Your Ladyship in this regard will look at Patilizwe and see the similarities there. Then we say, my lady, the extension of the panel wasn't authorized by GDID's own SCM policy. And we referred to this, my lady, in the founding affidavit at 078-61, paragraph 113, and the relevant clause, which is clause 9.18.1, which can be found at 028-462, which provides, my lady, that where a deviation for competitive bids cannot be sourced due to urgent or emergency cases, other means such as price quotations or negotiations must be used. Now, in this case, my lady, there was no emergency and no other means were used. And we submit that the extension of the panel for the purposes of refurbishing the hospital or any of the other works does not amount to an emergency. In fact,
Yeah.
Yes, my lady. Of course, we know as a matter of fact that the extensions or some of it was done even before the emergency called COVID-19 even hit our shores, my lady. So that could not be a valid basis for the extension in terms of the GDID's own SCM policy. Then we say, my lady, in addition, as we know, the GDID memorandum spoke about the panel having to be extended because of a lack of proper planning. This is what the Treasury instruction says, my lady, at note 6, 2007/2008, which your ladyship will find at 028-236, clauses 2.4 and 2.5.
This is the GDID note.
No, my lady, the Treasury instruction. Yeah, note 6. Note 6 of 2007/2008.
And clause?
Clause 2.4 and 2.5. At case lines 028-236. Where the Treasury says they note amongst government departments and state entities that there's been a lack of application of these procurement procedures, and there's been an abuse of emergency procedures, and they say the following: a lack of proper planning does not constitute a reason for dispensing with prescribed bidding processes. And then again, a Treasury instruction, my lady, a reference is Treasury instruction note 3, 2016/2017 at clause 8.5, which is at case lines 028-319, which allows for other deviations other than an emergency to take place in exceptional cases and subject to prior written approval from the relevant Treasury. The memo from the GDID says nothing about obtaining such approval. We submit, my lady, that the extension with respect to the Judge President, that the finding in that regard was incorrect, a prima facie finding that the extension of the panel was valid. Then, moving on from the panel, the suggestion or the submission is that once you on the panel, it means that any appointment subsequent to that is lawful. We dispute that contention. We know that as a matter of evidence that Mr. Tabani, the official concerned, failed to hand over to Mr. Du Toit any documentation pertaining to the alleged extension of the panel or its composition, and no evidence was obtained by the SIU investigators that the GDID in fact employed a manual rotation basis for members of the panel. Your ladyship will see that reference in reply at 100-56, 100-57, paragraphs 176 and 177. Now, the case was also made that there was the initial.
Sorry, Mr. Arendse, you froze up again?
Sorry, there was the submission that the sixth respondent, for example, was on the panel initially via a 2017 tender process. Now, obviously, the SIU can't or couldn't do anything about that because it wasn't aware of that in 2017, and it was before it received its mandate to do this investigation. Now, the panel itself, my lady, expired on the 29th of February 2020, but the PSPs were issued with appointment letters in March 2020. That reference is at case lines 078-73. So the purported extension, my lady, wasn't or couldn't be allowed simply because of COVID-19, for the simple reason that it wasn't even applicable in February 2020.
You mean COVID? The COVID regulations and pandemic was not applicable in February 2020.
Wasn't applicable in February 2020. And then the point we made in relation also to the contractors is that there's some 100 plus PSPs on the panel, and there's no answer as to why only the 3rd to the 7th were the chosen ones. Now, Mr. Klopper had rightly and fairly, and I'm sure I would have done the same in his position, about Judge President Madiba's prima facie finding that the 6th respondent appointment was regular. She nevertheless found, my lady, that the SIU had made out a case for review and setting aside in that very judgment. And this is what she says at paragraph.
Just a minute. Yes, which paragraph?
Paragraph 55 of the reconsideration judgment, my lady, where Judge President Madiba says, ProServe's appointment is vulnerable to be reviewed on the basis of other grounds relied upon by the SIU. The other grounds for review which Judge President Madiba did find to have been established, again prima facie, paragraphs 56 to 74 of her judgment.
I lost you there. You said the ground she refers to?
The grounds on which she refers to and relies on for her prima facie views are at paragraphs 56 to 74 of the judgment. One of them, my lady, is rationality, the irrationality of the entire project, and which I've submitted previously today has not been refuted by any of the respondents.
Yes.
If I may move to another topic now, my lady, the fees charged by the 6th respondent and Mr. Klopper's assertion that he did not over.
I'm not sure whether you're having a signal issue there, Mr. Arendse, but you keep freezing up. You say fees charged by the 6th respondent.
Yeah, the fees charged by the 6th respondent. It's asserted that they didn't overcharge because the fees were regulated by legislation. We refute this, my lady. It's denied. Ms. Mutara's opinion states that the usually applicable rate for PSPs is between 10 and 12% of the contract value. And these rates are far less than what's provided for in the Government Gazette. where it works out between 25 and 30% of the contract value. But these rates are unworkable and are never applied in practice when a tender process is followed.
The 10 to 12%, is that what you say?
It works out between 25 and 30% of the contract value. But she said that the applicable rate is between 10 and 12. And
is it the 19% that you're referring to, which is 20 to 30%?
No, my lady. Ms. Mutari, in her opinion, says that the usual, in denying that it's regulated by legislation, she said that the rates usually applicable to PSPs is between 10 and 12% contract value. Now, these rates are far less than provided for in the Gazette, which Mr. Klopper referred to, where it works out to between 25 and 30% of the contract value.
So that's the 19% we were referring to. Is that not gazetted?
Yeah. They kept their 19%, my lady, despite it being
higher than the gazetted rate.
Yes. Now, it was alleged that Ms. Mutara had reduced it to 12.49%, but that's not in fact the case, my lady. I think I referred to earlier, it's mentioned 12.49%. Yeah, for the purposes of her calculation, she kept it at 19%. I think your ladyship can accept that as a common cause. Of course, we also know that subsequently in June that was agreed. So we submit, my lady, that the contract price, as I mentioned at the outset, escalated tenfold. We also know that the PSPs and the contractors themselves completed the bill of quantities, which led to the contract price being determined. We also know that Ms. Mutara's firm, which is a quantity surveying firm, usually obtains a contract fee of between 10 and 12%. So we submit that if GDID had embarked even on price quotations, there was the possibility that other PSPs may have agreed to a lower percentage than 19% of the contract price. Now, something was made of a mistake made. The 13th respondent says in its answer at 096-277 that an air conditioning provider invoice was incorrectly reduced by Ms. Mutara's team. Mr. Swoboda admitted this in reply. But this invoice in question is only a pro forma invoice and was not signed and contains no delivery note. This is dealt with by Ms. Mutara in reply at 100-157 to 100-157 to 100-160 at paragraph 605.
Sorry, 100- I can't write as fast as you talk, Mr.
Sorry, my lady. 100-157 to 100-160. where she admits the mistake made by Mr. Swoboda, occasioned by the BOQ, which was unclear as to the numbers.
Yeah.
The allegations, yes, start at 100-157. And from that, your ladyship will see that the SIU denies that the invoice is proved. So it is not conceded that any reduction as to the 13th respondent's overcharge and commensurately the 6th respondent's fees is required.
Mm-hmm.
So this is one of the errors Mr. Klopper seizes on, and then he went on to say that there could be many others. Doesn't mention them, and of course we submit there's nothing that is supported by the facts. The 6th respondent itself didn't bother to call an expert or get an expert report. And the deponent to their answering affidavit doesn't pick up any errors in Ms. Mutara's calculations. That one mistake is picked up by the 13th respondent. My lady, those are our submissions in relation to the 6th respondent, and we submit like we would and do in relation to the other respondents that the application be granted in terms of prayers 1 to 5 and 7, and in the case of the 6th respondent, including the costs reserved from the reconsideration applications. This is 4th. So, my lady, it just leaves me to deal with the 4th respondent, and we will try and avoid repeating the same.
Well, I don't think there's anything extraordinarily new that they have raised in the heads that were filed rather late to what some of the others were saying. So
Yeah, we flagged the material disputes effect, which I think we've dealt with. Mm-hmm. And on the merits. Sorry, my lady, just. So we just want to say something, my lady, on the merits. The head suggests that the 4th respondent incurred additional costs in the form of accommodation costs for their teams, the hiring of other quantity surveyors. They also have 3 teams and had to coordinate them. They say at paragraph 53 of their heads, at 05450, that problems such as scope and designs, availability of suppliers, small community enterprises involvement, rates of labor and payment delays led to the ballooning of the scope of work, which was not properly designed from the outset. That's why we mentioned this, my lady, because we submitted this is an important concession from an appointed quantity surveyor who was responsible for the bills of quantities. The fourth respondent is not a quantity surveying firm. It is an architecture firm. In the heads at paragraphs 28 to 31 at...
Just a minute, sorry. Sorry, in the heads.
Yeah, in the heads, my lady, it's the reference is at 054 540, paragraphs 28 to 31. Council said that Ponolopele specializes in architectural services, but also other related service rendered by an allied profession as defined by the South African Architectural Council. And in the heads at paragraph 30, they claim that the regulatory body lists them as able to perform also schematic design drawings and documents, including mechanical, electrical, plumbing, and other details into the design, and satisfying building code and zoning regulations, and ensuring project approval and permits from the regulatory authorities. And then a loose quote, and amongst others is also quantity surveying services. There's no reference to this in the corresponding paragraph in the heads of argument. And these are submissions that are simply made in the heads for the first time with no factual basis and no reference to the record. They claim now to have quantity surveyors not only as associates but as experts, and their training and experience qualify them to advise on cost and contractual arrangements. We deal with this, my lady, in reply at case lines 135, paragraphs 81 to 85. And in essence, my lady, and this is quite serious, in essence, we submit and point out that they are not registered as a multidisciplinary practice. They are not permitted to provide services other than architectural services.
You say not registered where?
They're not registered as a multidisciplinary practice. They're only registered as an architectural.
Yes, that's what I mean. Are you saying that they're not registered in terms of their professional registration or on the database of the GDID?
On the professional body, my lady. They're not registered. And of course, my lady, we know on the facts, because we also pointed this out in the papers, they're not even registered on the panel, on the GDID panel. To the extent that the extension on the panel was valid, they're not even registered on the panel to provide quantity surveying services.
Yes.
Also referred to the SLA, we submit that wasn't even...
Sorry, Mr. You froze up again, and all I heard was SLA.
Yeah, that's the last submission, to the extent that they concluded an SLA, which made...
You keep freezing up again. That is said in respect of the SLA?
Sorry, my lady, we don't need to make that submission.
Okay, so you're leaving that out, okay? Is that your submission?
No, those are our submissions, my lady.
And I take it that in respect of the fourth respondent, you equally ask for the application to be granted against them.
Yes, my lady, with costs on the usual basis, costs of 2 counsel, including costs of senior counsel.
And you ask for the same in respect of all the others, I take it.
Yes, my lady, including those, the sixth respondent, the costs of the reconsideration.
Yes. Well, Mr. Klopper has indicated which costs still need to be considered.
Yeah, no, he said that he wanted his costs. So if he's wrong and we're right, then we want our costs.
Sure. Right, thank you very much. I am just now inquiring if the representatives of the first respondent are here.
Good afternoon, my lady. I am here.
That Ms. Makapela. Yes.
Yes, it is, my lady.
Yes, Ms. Makapela.
Thank you, my lady. My lady, although our heads of argument appear on tab 54 in case lines, owing to the practical nature of the basis for our argument for costs, I will not be referring to the heads of argument that we have filed. And so I'll only be referring purely to the rules of procedure as well as a case to make our case for why it is that the sixth respondent should be liable for the cost occasioned by the first respondent.
Is that, sorry, no, hang on. Is that for this forum?
That is, my lady, indeed.
Because,
indeed, and I'll explain how and why. I'll make the distinction between why we're not involved in the main application and how it came to that Monday we were before this court and had incurred those legal costs.
Because then I would have to obviously give Mr. Klopper a chance to address as well.
Yes, my lady. I will explain at the end, my lady, why it is that it is necessary. And I'm hoping as I take my lady through, it becomes quite clear.
Well, I hope this is a short, crisp argument.
I will try as much as possible to make it crisp,
my lady. Before Ms. Pella proceed, I think this is uncalled for. Your lady would have seen that the issue between the sixth respondent and the first respondent is totally conditional upon your lady's ruling.
Mr. Klopper, I will be dealing with all of that in the very, very brief submissions that I make. I do request your humble indulgence in that regard. I think we had been quite clear on Monday that this is what we were going to be doing. We had asked to make submissions in relation to costs. And so I think as much as it is not your preferred way of doing things right now, it is very necessary for certain information to be placed before this court. And so I seek the court's indulgence, please, my lady, in the interest of my client.
All right. In the interest of justice and giving you a hearing, I'll give you that hearing. Let it be short, crisp, and then I'll give Mr. Klopper a chance to respond.
Thank you, my lady.
Mm-hmm.
My lady, but for the institution of the conditional counter application, our involvement in these proceedings would have stopped at our filing of a notice to abide with a reservation of rights on the 9th of February. So if,
give me a minute.
Sorry, my lady.
Mm-hmm.
And in instituting that notice of intention to abide, we withdrew our notice of intention to oppose. We had initially sought to oppose these proceedings as first respondent, and then we withdrew that and filed a notice to abide. Now, on 1 August, the sixth respondent files its answering papers, and the following day files supplementary answering papers together with a conditional counter application in which it sought for Anglo to indemnify it. Now, the merits of that I shall not go into. However, just to point those dates out to Milady, because then when we responded to the counter application on 10 August with a notice of intention to oppose, that is when counsel was appointed to deal with the counter application and the merits therein. So that was August. We followed the
So you say you only appointed counsel after you received that notice?
Indeed, my lady, because at that point there would have been no reason to appoint counsel. We had already filed a notice of intention to abide. And so on the basis of the counter applications institution, we then, Anglo, then brought on counsel. And the answering papers in the counter application were delivered on 9 September. And then in line with the directive that was issued by the tribunal president, to which all the parties here have been bound, we then delivered our heads of argument on the 21st of October. Heads of argument, again, my lady, in the conditional counter application. We were not involved in the main application, having filed that notice of intention to abide. Our heads of argument appear with the final page therein.
Sorry, just give me a moment, please.
My apologies, my lady. I'm just trying to make it as quick as possible.
Yeah, I wish I could write as fast as you can talk.
Now, it's important in mentioning the date of 21 October for the filing of the heads, for me to note that to date, the sixth respondent has not filed any heads of argument in the counter application that it instituted itself. So not on the 21st of October, not on the dates of October that were required by the directive, not even on the morning that it was filing its heads of argument in the main matter. And so Anglo briefs counsel to counsel, we respond to the answering papers, we file heads of argument, and then we block off the week of this hearing because we're told we have to either make ourselves appear on the stage to explain how we are to deal with the counter application, whether it will be after or whether it will be dealt with at the start of the proceedings. But instead of just coming to this proceeding on the 14th, we on the 1st of November write to the attorneys of the sixth respondent asking after the heads of argument. And we ask, where are these heads of argument? Because we are now dealing with court in 2 weeks. They respond they respond a week later. And this is where, my lady, the correspondence that we have uploaded under tab 099 and that we have handed to your ladyship's registrar this morning becomes of importance because they respond on the 7th of November. And I refer to the letter from IRS attorneys at 099.
Just a minute, just a minute. Sorry, you say they responded and where is that?
So that is under tab 099, case line 099-105. They respond to us a week later, us asking after where their heads of argument are so that we can prepare for the hearing. And they respond and say, in brief, my lady, I will not read the entire letter, but of importance of paragraphs 3, 4, and 5 in their letter. And it will be recalled that on Monday, when the contents of this letter were brought up, counsel for the sixth respondent was very emphatic that the understanding that we had and the understanding that they had in writing the letter were two different things. And so that is the reason why we have uploaded it, because it does assist us in what we're going to be arguing with regard to costs. So under paragraph 3, they state that, paragraph 2, we refer to your email transmitted on 1 November 2022 at 7 p.m. Kindly be advised that we and our client investigated the matter of the jurisdiction of the Special Tribunal and concluded that the Special Tribunal had no jurisdiction to adjudicate on our client's conditional counter application, and that as such, jurisdiction lies with the High Court, where to appeal from the Special Tribunal lies, namely the Gauteng Division. Paragraph 4, considering that our client's counter application could only become alive upon the Special Tribunal first granting relief against our client will only pursue, if indeed such became necessary, during a possible appeal to the Gauteng Division, or alternatively, possibly in a future or separate application to the Gauteng Division. On its own, these two paragraphs would have been the end of it. It would have just been the attorneys informing us of some or other deliberations that they'd undertaken. But then they make the undertaking at paragraph 5 as follows. Kindly then be informed that our client's conditional counter application will not be moved before the Special Tribunal, and that the Special Tribunal does not have any jurisdiction to adjudicate same. Kindly be advised as such, and feel free to refer any inquiry in regard to the matter directly to the writer for attention or discussion. We respond the same day, my lady, and we ask, in accordance with the rules of the special tribunal, will they be tendering costs and will they be withdrawing the matter? And the special rule that I would like to point to is, first of all, Rule 10 of the rules for the conduct of proceedings on special tribunals, which says that the rules applicable to applications also apply to counter applications as the context allows. And so it says in Rule 21, sub-rule 1, a party seeking to withdraw the proceedings must deliver a notice of withdrawal in which it tenders the costs of the suit as soon as possible. Sub-rule 2 requires that if the party has not tendered costs and has not withdrawn the matter, any other party may apply for the costs of the suit. And so we wrote to them on the 7th of November, and that appears at tab 099-107 that has also been provided to Milady's registrar. And we ask two questions. We first confirm receipt of the email the same day. And then we say, we note that your client will not be proceeding with this counter application. That being so, please urgently advise whether your client will be delivering its notice to withdraw and whether it will tender our cost on an attorney and client scale as sought in our client's affidavit. We then give them the date. Please revert to us urgently by no later than 2 p.m. tomorrow, Tuesday, 8 November, and we tell them why. In order to curtail further legal costs being incurred, because as you know, the court hearing is days away and our legal team is currently preparing for the hearing. That was the Tuesday. They had Wednesday, Thursday, Friday, milady, Friday last week, before this week's hearing. At 6 p.m. in the evening, we write to them again. We say our correspondence below refers. We have not heard anything from you. We have not received a response from you. We called your offices in respect of our correspondence below, and your offices advised we would receive a reply on 10 November 2022. That was the day before. And so they write to us indicating that they want to withdraw. They then invite us to engage with them on that. We ask them, will you be tendering costs? Will you be withdrawing as is required by the rules? They tell us nothing. And so we then have nothing to do between Friday and Monday in relation to whether or not do we prepare on the basis of this counter application, or do we prepare for something else, or do we just sit back and just think, well, they will uphold their end of the bargain as indicated in their letter, and so we shouldn't have anything to worry about. We then come on Monday, myself only. My senior has said, since they're withdrawing, there's no reason for me to appear and incur further costs. When we get here, what does Mr. Klopper tell us? He tells us we've misunderstood the import of their letter. He tells us they're not withdrawing, but he does then peculiarly tell us they will not be proceeding with this. Milady, that is not how it works. These are legal proceedings. They brought us here. They brought the fourth respondent from out of obscurity, and then they asked us to respond to their case. Mr. Klopper, I will please let you interrupt me, but if I could please just continue with this thought. They then, milady, spent the entire week of these proceedings, notwithstanding that we had raised this in email, notwithstanding that we had raised this on Monday, and had even raised the letter out of respect of not making this letter known to the court, and having respect for my colleague and saying, perhaps you may not have had complete regard for the letter, please, or perhaps the attorneys had not appraised him on the contents of the letter, but that was our understanding of the letter. Now, the import of this is the following. Anglo has come to this court, to this tribunal, my apologies, to answer for a case that it was asked to answer to by the sixth respondent unprovoked. They then realize on a bright sunny Monday morning on the 7th of November that they have made a mistake, according to them, that this special tribunal does not have jurisdiction. Now that's a legal conclusion, but they then make it nonetheless. And they say on the basis of their legal conclusion that they've come into since their investigation, I think they put it in their letter, they will not now be proceeding. Milady, can we imagine if the special investigating unit as applicant did that, if it told all the parties in this matter that due to the fact that they've realized they don't have any jurisdiction, they will not be proceeding with proceedings, and that is that. It does not work like that. That's why the rules are there. They say if you've brought a party to the special tribunal and then you realize for whatever reason you need to withdraw your case, you tender costs. It's as simple as that. And the rules make it quite clear, as soon as possible. Now, having cited Rule 10, which says that the rules applicable to applications are the rules that are applicable to counter applications, and the fact that they have not withdrawn, notwithstanding the fact that they have been in this matter since Monday, Rule 10 sub Rule 5 then becomes applicable, my lady. It empowers my lady, to dismiss or make any order that you deem meet to ensure a just and expeditious disposal of the matter. It means that as we currently stand, the counter application is still live, regardless whether the sixth respondent still wishes to go and reinstitute it in the forum that it feels has jurisdiction. It just simply cannot turn its back on this litigation that it started without any preempting from anyone. The first respondent had said, we will abide. Another option would have been to go through these proceedings, and then if this tribunal finds the sixth respondent to have been guilty, to then say, now we will say that they need to indemnify us for whatever we've been found guilty. But instead, no, they instituted on the same exact day that they bring their answering affidavit. And we as Anglo have to then have counsel be responding to that, researching for heads of argument. And then they want on the day, a week before the hearing, to then say, no, actually, we change our mind. We're going to institute these at another place. And when we see clarity, they then want to ignore us. And then we want to come to this tribunal and look the way that we did on Monday. My lady, it cannot be. It simply cannot be. And to quote the Constitutional Court in closing, it had occasion to consider cost orders and cost awards in tribunals with specific reference to the Act and the rules of procedure in tribunals. And I refer to paragraph 29 of the following judgment. Competition Commission of South Africa versus Pioneer Hybrid International Inc. and others. 2014-3. Butterworth Constitutional Law Reports 251 CC. And the Constitutional Court, they stated that the costs power.
Sorry, what page was that, Ms. Makapela?
It's paragraph 29. My apologies, my lady. I do not have the page number, just the paragraph. The Constitutional Court states there that the costs power is an important tool for the tribunal to regulate its own proceedings. And having quoted that, I make the following point. The conduct of the sixth respondent in these proceedings, both prior and during these proceedings, warrants a cost order. It is such that it has been in the complete disregard of the first respondent, its cost that it would have to incur in briefing counsel preparing, and then counsel not knowing whether or not to continue to prepare, counsel not knowing whether or not to appear or not to appear, and counsel having to back and forth be advising client on these changes that were happening on the daily without any prior warning or communication from the sixth respondent. Having filed their own heads in the main application on the morning of the hearing, we did not even get an indication as to whether or not they ever plan on filing heads. In other words, did they ever even plan to argue this matter, or did they simply want to issue a conditional counter application for the sake of issuing one, and then when they felt like it was no longer conducive to do so, or no longer a good idea to do so, then simply inform a party that no, we've changed our mind, we've had an investigation in our office, and so I hope you don't mind. It just cannot work like that. And if I recall, on Monday, Milady came down quite strongly on the parties for some of the disregard to the rules and the directives that the tribunal president had set in the conduct of these proceedings. In closing, Milady, at the tail end of these proceedings, it becomes quite clear that the first respondent, Anglo-American, had nothing to do with these proceedings. We did not have to be here on Monday. We did not have to be preparing heads. We did not have to be here on brief, still waiting to hear whether or not we would be heard on costs. None of this was necessary, but the sixth respondent insisted, notwithstanding the fact that we constantly were trying to correspond with them to try and enter into some type of agreement to have this conditional application be dismissed, or rather to have it by agreement be withdrawn. They have not come to the party on any of these. And it is procedurally irregular. And quite apart from its procedural irregularity, on a collegial perspective, the reason why I was perplexed was because then it ended up having to be a junior counsel being thrown under the bus, making as though they made representations that were false to a court of law. As an officer of the court, I consider that an indictment even to my character, quite as an aside to the procedural aspects of the case. Quite apart from that, Milady, I trust that in explaining how we have been inconvenienced time and time again by the sixth respondent respondent, we have made out a case not only for a cost order, but for the dismissal of the counter application that is before this current court, if the sixth respondent is not going to go ahead and pursue it. We seek for cost on an attorney-client scale, as we prayed for in our answering affidavit. And if there are no further questions, my lady, those are our submissions briefly on that point.
Well, as you were speaking, I see that a notice of withdrawal of the sixth respondent's notice in terms of Rule 34. I don't know what this is.
My lady, may I assist you?
Yes, what is this now?
My lady, your lady does not need to concern yourself about the Rule 34 proceedings which took place between the sixth respondent and the applicant, and that's got nothing to do with nothing. The registrar should most probably not have provided that to your lady.
All right, so that's got. I thought it was when I saw notice of withdrawal, I thought it was the withdrawal that Ms.
No, my lady, that's Rule 34 in terms of the uniform rules, which has.
Oh, it's that settlement. It's that settlement matter.
Yes, my lady, but unfortunately, that may I ask your lady simply to ignore that.
I will. I'm very good at shutting things out.
Thank you, my lady. If I may return quickly to what Mrs. Makapela says. I
just want to finish up her last submission. I was busy reading that. So just repeat your prayer regarding costs again, Ms. Makapela. Costs on an attorney and client scale. And what was the last bit?
As prayed for in our answering affidavit, in our answering papers, my lady.
All right. Okay. Good, Mr. Klopper. Briefly and quickly.
My lady, I will try to be much more to the point that my learned colleague is. My lady, your lady have seen the notice of motion conditional counter application. What I found quite strange from my colleague is that when she, or Advocate Makapela, when she reads, she skips over the word conditional. Your lady will see on at paragraph 099-2.
Just a minute, just a minute.
And this is the building block where your lady need to start.
So it's 099-2.
Yes, my lady. Lady, that's the conditional counter application notice of motion. Now, my lady, may I be permitted to read, and then your lady don't have to page to it. Be pleased to take notice that the sixth respondent hereby give notice that at the hearing of this application, on condition that the tribunal orders the sixth respondent to repay any amount of money, the sixth respondent then will request the following order. So it's a very emphatically clearly stated conditional counter application which cannot come alive before the tribunal has made an order against the sixth respondent to pay an amount of money. That's right in its proper law. Now, how my learned friend cannot read that and understand that, and how a prestigious law firm cannot understand that, is mind-boggling. What transpired is that the first respondent, your lady will remember, and it is correct as she pointed out, this document was launched on the 2nd of August 2022, together with the answering affidavit of the sixth respondent. That is perfectly correct. What the first respondent did is on the 30th of August, it transferred the property. And then it filed an affidavit after that saying, well, we're not the owners anymore. Now, let's go one step further then, my lady. The conditional counterclaim clearly stipulates that this conditional counterclaim can only become alive after judgment of the tribunal and after a judgment ordering money to be paid by the sixth respondent. That's very clear. So what happens? My lady, may I refer back to the letter which my learned friend relies so much on? That's the letter by my attorney of record, 7 November 2022. That is the one which was now transmitted and referred to by my learned friend. But I need to clearly state. Paragraph 4 of that letter very clearly says, considering that our client's conditional counter application could only become alive upon the special tribunal's granting of relief against our client, in bracket, the condition, close bracket, our client will only pursue if indeed such become necessary during a later stage. Now, what is more clear than explaining that? What is the result? The result is a opportunistic email a few days later which says, oh, so you are withdrawing your application. Where does that come from? Nowhere in the application, which is strictly conditional on a condition which has not yet realized, which we will see in future what the future holds. Now suddenly, because there's a letter which says it's conditional and we will not move it, and I mean in law we cannot move it before the tribunal has made an order for payment against the sixth respondent. That's common sense, let alone law. Now there comes a demand to say, well, you must withdraw your application. That is, with all due respect, rather ridiculous. To say you must withdraw, you are not proceeding with your counter application and therefore you must deliver a notice of withdrawal. Let me remind your lady on what is written. And I'll read it again. This is the email of 7 November sent by attorney Lindani Majulani of the first respondent's attorney. It writes, we note that your client will not be proceeding with its counter application, full stop. That's not the whole truth. The whole truth is we will not proceed until an order has been made because it's conditional. Then it says, that being so, advise one whether your client will deliver a notice of withdrawal. Where on earth can any reasonable person think when you've written a letter that the counter application will not be, the conditional counter application will not be moved at this stage because the condition is not yet in place to trigger it? How on earth can any reasonable person think that equates to a withdrawal? Then how on earth can anybody reasonably think that equates to automatically causing or requiring a tender for costs? My lady, that is simply mind-boggling. The first respondent knew from reading the notice of motion that this is a conditional counter application and the only triggering factor to make this conditional counter application alive is a judgment by the tribunal ordering the sixth respondent to pay some money. That's clear. Why the first respondent incur legal costs at any stage is unknown. And it's their own frolic. What one would have expected of a reasonable person is, if they unsure on what does a conditional counter application mean, why didn't they write a letter requesting clarification that they understand rightly or wrongly that this counter application is conditional on a future event? And if that letter was written, that letter would have most probably be answer to say, yes, it is conditional on a future event. At this stage, let it lie at the side. We'll deal with it after the judgment of the tribunal. That's common sense. But no, that's not what the first respondent do. The first respondent wait until they transfer the property on the 30th of August. Then they file an affidavit where they basically explain we're not the owner of the property, and now they want to come to the tribunal, and because the sixth respondent is not, for some reason, moving a conditional counter application before the condition upon which it is based is basically triggered, now the first respondent suddenly want costs. They are premature in the worst possible sense. And they know that if they read the notice of motion. My lady, you ladies should not be concerned with any issue of this. If there is a judgment in future which does trigger the counter application, the tribunal or the High Court or any other forum will be approached to deal with the conditional counter application. That's how the law works, and it's rather common sense. So, my lady, we submit at this stage, your lady should not concern any of this request on behalf of the first respondent. They'll, if the triggering condition comes into effect in future, they'll have all the opportunity they wish to deal with this. But on their total misunderstanding of what is conditional and what does a conditional counter application means, if they incurred cost on that request, my lady, with all due respect, it's not the tribunal's problem or anybody else's problem. This will be dealt in future, my lady. So we submit this is not for your lady to be concerned about at this stage.
Yes. Do you have any response, Ms. Makapela, shortly, crisply? Ms. Makapela, any reply?
Just briefly, my lady. Listening to Mr. Klopper, one would swear that the proceedings of this matter are dependent on how the sixth respondent feels. That's not the case. We had strict parameters within which to work. Every single respondent that is involved in this case, whether it was condonation applications or conditional counter applications, all applications were dealt with within the forum of this particular matter. That's why the case number is the same. Now, having said that, if the directive was that we file affidavits on X date and we file heads of argument on X date in relation to these proceedings, then any party doing so was not in the wrong. The first respondent had every right to respond to the counter application. We understand what a conditional counter application is, notwithstanding Mr. Klopper's condescension in explaining to us what it is, as he did on Monday. But that is not the point here. It is that they indicated that they would not be pursuing the matter before the special tribunal. That can only indicate that they are not doing that. There's no other indication. If there's a paragraph that says we will not be moving it before the special tribunal, and that special tribunal does not have any jurisdiction, how are we to look, my lady, when you give your judgment and then we come back to the very same format or very same forum that the sixth respondent claimed did not have any jurisdiction? If they are to institute a conditional counter application, they will do so in accordance with their letter. They will do so on another forum, in another forum, conditional to the judgment that my lady is going to issue. And so the proceedings before this particular tribunal, we can consider them done today. We're not going to come back. My lady's not going to issue out a ruling saying we're coming back on X date to argue the counter. As they have already indicated, they're not going to pursue the counter within this forum. And so the costs occasioned in this forum must be dealt with. And the application that was brought before this forum must be finalized. And the rule says it must be finalized to ensure a just and expeditious disposal of the matter. Now that Mr. Klopper then engages with us in this discussion and not their attorneys as they had indicated is of no moment. nor is it that clearly his attorneys and Mr. Klopper have a very different understanding of what they meant when they wrote this letter. But the only understanding that needs to be before this court is one: there was no conditional counter application that was proceeded with by the sixth respondent, not in filing their heads, not in filing a reply, and that cannot be due to their understanding of what a conditional counter application is. It's due to their feeling that this conditional counter application is not ripe for hearing before this forum, or is not the application to be heard in this forum. Regardless, the point of the matter is something has to happen with this application that they instituted, and it cannot merely go away simply because Mr. Klopper has explained to us today the fundamental foundations of what a conditional counter application is. The rules are very clear. The rules are very clear, and the rules are not made for the litigants. The rules are made for the court. And so if we are saying, or if Mr. Klopper is saying that Malady should just disregard the rules of this court in favor of his understanding of what he meant and what his client meant, we cannot go like that, Malady. That's not how it works, unfortunately. My apologies to Mr. Klopper. That simply is not how it works. If we occasioned costs on the understanding that we were to come here during this week to argue or to make arrangements to argue a conditional counter application, which they then indicated they would not be moving, the only other thing for them to do is to remove it. And removal is done by withdrawal, not by sending us a letter or ignoring our correspondence and then coming on here and acting like that correspondence never happened. And so really, Milady, not to belabor the point or to beat a dead horse, simply just to say the first respondent incurred costs that but for the sixth respondent's institution of its conditional counter application would not have happened. The sixth respondents proceeded to persist with that conditional counter application right up until we filed heads of argument. When they realized through their special investigation that it was not ripe or it was not the correct forum to bring it, they think now we should all just acquiesce just because they say so. It does not work like that. It doesn't work like that. That is it, Milady. We just need to.
Yes, I will consider that when I'm considering all the other matters. Right, I believe there's no further matters to deal with, Mr. Aronson.
My lady, no, not from our side, my lady. It just remains to thank you and your registrar and all our colleagues and their instructing attorneys for making this week possible and for finishing. And now the ball is firmly in your court, thankfully.
And you can rest easy. It won't be next week that the ball gets rolled back to you. I must say from my side, thank you to each one of you for conducting yourselves, you know, in a manner that saw the expeditious hearing of this matter and completion of the hearing. It's an enormously big matter. It's many legal issues. And all of you we're working under some pressure, some of you at any rate, to produce documents even after this matter started. I'll have something else to say about that, but thank you for all your efforts. And I want to say special thanks to Ms. Mashitisho. She's been an absolute star. Thank you for all your support and help in this matter, which has been not an easy matter, and I do appreciate the help and support. So thank you once again to each one of you, and go well.
Thank you, Malady. I just want to thank you, Mr. Arons. He said that at the moment the ball is in your court. I think the ball is in your tribunal.
It's in my tribunal. Yes.
That's very cute. That's very cute. He doesn't acknowledge you as a court.
Yes, he's not acknowledging me at all, I see.
Thank you, Malady.
Thank you very much, ladies and gentlemen.
Thank you.
As the court now. Thank you.
As the court pleases, my lady.
Thank you. He says, as the court pleases.
Oh, as the tribunal pleases.